Need to short serve and move ballot. The matter was mentioned yesterday by the Lordship. 14th is the vote. Therefore, ballot, if Lordship kindly gives it on Monday. 14th is the vote, ballot. If your Lordship gives it.
14th is on?
14th is on 14 July.
14 July.
June, sorry. Ballot.
That June has gone.
July. 14
14
July.
July is Sunday.
So therefore, they are taking the votes on Sunday. I'll be praying, my lord, if your Lordship keeps it on 8th or 9th, 8th.
Very well. No problem. Today we are on 4th.
4th.
You serve and file the affidavit of service?
Yes.
You have got the number?
No, my lord, I am seeking leave so that.
No, then first obtain number then.
My lord, if I go and filing in.
You come up.
They will.
I am granting you leave.
Yes.
Obtain number, mention at 1 o'clock.
My
lord. 1 second. In view of the urgency pleaded. আসুন লিখে দিন ওটা না আপনি না ওই তো এন্ডোর্স করতে হবে in view of the urgency pleaded leave is granted to obtain regular number. Then you mention at 1 o'clock.
My lord, for upgrade, sir, under unauthorized construct.
No requirement of mentioning, sir. You just give the serial number, cause title to my officer. Right? And whenever you will come to move the matter, you will bring my order. At least 60, 70, 80 orders I have passed by this time. So which one suits you, you bring with the necessary corrections. Only corrections will be by pencil, you make the correction. Only the correction will be cause title, appearance. Then the material correction will be private respondent numbers and the date of representation, annexure of that, and page of the writ petition. That's all.
Some matter to be forwarded before the Pradhan and you.
Some other?
Some matter.
Take microphone.
Some matter direction should be given to the Pradhan and some matter direction should be given to the block development officer.
By block development officer in which
there is direction, DM restraining the block development officer not to construct any road over the private.
That is a different issue, which are not covered within that orders. I will hear separately and pass separate order. Not a problem.
Grateful to us.
But which are common matters?
Yes.
Those, so that time can be unnecessary, will not be wasted. I will take in a bulk, pass the order.
Grateful.
And whichever is a different issue,
yes,
I will hear and pass an independent order. Don't worry.
Grateful to us.
Always. But unless item numbers are mentioned, it will not be listed. Follow the instruction in the July monthly list, special note.
May I be permitted to...
Who is senior? He's senior. Let him take the chance.
Let him do.
He's bigger.
You're much taller.
He's bigger.
He's much taller.
Yes.
All right.
I mean, all Panchayat election matters. Yesterday, I've been informed by Mr. Mahatam that your Lordship will be hearing maintenance issue on those. There are bunch of matters. Those all matters can be taken up together. And only one matter. That in that matter, I have completed my argument. State has completed their argument.
That is neither here nor there because I don't know anything about it.
And written notes of argument was already filed.
I don't know about it, sir. You have to have de novo.
Either it has to heard de novo or it has to be
de novo.
De novo. The only thing is unless it is heard and disposed of within time election, so for elected for a certain period.
If I take even one matter on the maintainability issue, like yesterday, I got a matter which has come from the decision of the election commission.
Right.
Court directed to take a decision by election commission. That I will hear separately. Of course, that cannot be.
There are similar matters.
But simpliciter, repolling, challenge of election, setting aside of the result and repolling, fresh election, while publishing the result, irregularity, those are to be dealt with in a separate judgment, one single judgment.
Yes, if you kindly fix a particular date, because these are...
Today is fixed for one matter.
No.
That's right. Be there. Be there. It's a point of law.
Item number 26 is that
Sir, whatever is in the list, be there. Point of law. What will be the argument? You may supplement. Let's say Mr. Chatterjee has argued X, Y, Z point. You think you will have to argue B, C, D. In addition, you'll argue B, C, D.
No, Lordship, the
can we
only thing is
provide the list of matters of similar matters so that all this can be taxed
so
together?
together,
Not
Other than that, to argue the point of maintainability, facts is also relevant.
No. Sir, facts is relevant. Let
One
me
cannot
first-
decide the maintainability of the petition without going to the facts. Undisputed.
Correct.
Court cannot
Correct. Now
decide
let's
facts.
say tomorrow I deliver a decision. Whatever way. In a separate matter, which might also appear after 1 month. Might appear. You might have a different case.
yes,
You might have a different case. You will distinguish that judgment.
Lordship,
That
I
will
have
be
a
difficult for everybody.
I'll hear you.
Can we do one thing? We shall take one from each and argue their case on the point of maintainability only.
Sir, you argue the maintainability point. I'm inviting you, sir.
Yes, madam.
Whenever the matter will be called on,
No.
let that matter
I'll
be
get
done.
one matter and I'll argue that.
Then
Lordship.
I will take from the list, if like you say 26.
I follow.
I will take 26.
I follow.
Not to worry. Yes,
Lordship.
sir.
there is one matter, Lordship, it is not in the list. It is filed quite long past, Lordship. The matter relates to an application made by one of the elected Panchayat Samiti member who claims to become the leader of the opposition as per the provisions. He is the sole opposition members.
That is a different issue. He
No.
claims to become
Oh,
the,
Lordship, that matter is not in the list. Lordship, kindly include that matter.
it will appear. in a-
At least 6-7 months, all corruptions have been taken
No, no,
place
all
in
right,
absence
all
of a
right,
leader
all
of
right.
opposition.
That has a different cause of action.
Yes, that's why we have filed it. I want to
You
mention
can
this matter.
Mention
Lordship,
after
today.
2 weeks. I will
Just
hear you
already
separately.
7-8 months have lapsed.
I will hear you after 2
Lordship,
weeks.
understand the importance of presence of the opposition.
Sir, I will hear you after 2 weeks. I will hear you after 2 weeks.
So
Don't worry.
kindly keep it after 2 weeks. I'm giving the number.
I will mention after 2 weeks. Remind me. Then let me do some work on this huge pending list.
And so far, these pending matters related to the Panchayat election is concerned, Lordship, I have a proposal. I have a proposal to make. Lordship, there are many matters. Some of the matters, as your Lordship said, that directly they have prayed for cancellation of the elections. And in almost all the matters, there are certain
Repolling,
order has been
repolling, mostly repolling.
Now, repolling has been directed after a decision of the election commission has come in some of the cases. That repolling is not directed. Their court has directed the repolling.
No.
Some matters
That
are
is
there.
a different cause of action.
So, Lordship, let us.
I told you one matter I got yesterday from the decision of the election commission. That has got nothing to do with cancellation of election. So that will cause separate cause of action. I will hear it separately. As you said, there is a direction by election commission to repoll, but not done. That is your case. That's right. Separate cause of action. I will hear you separately. Don't worry.
Some of the matters are the court has directed for repolling. That has not been done.
That first I have to decide the maintainability. Then for that I have
Now,
to decide the
Interim
maintainability.
order is already passed by the court. The question is that interim order
What is
cannot
the
be.
interim order,
There
sir?
are matters.
Absolutely. I got one, sir. One.
In that
many.
case, Lordship, that interim order has to be modified then. Lordship will have to.
What is the law of interim order, sir? Of course, subject to hearing you.
Private satisfaction is there.
Tentative.
The prima facie satisfaction was reached by
Right.
the
Court must
And interim order-
have that.
Then you will have to argue on those cases. You will have to argue. Prima facie view is the final view.
No.
You cannot.
All that we can say that court has observed there is prima facie case.
But if let me hear the maintainability first.
even
When-
even in case there some conflict will be there. Even if it is found that court has found a prima facie case. Suppose today your Lordship finds that there is no prima facie case.
Correct.
There will be difference of opinion on that particular point.
Okay, because there is a division bench staring at me. How does it matter?
And there is a Supreme Court staring on division bench also.
Lad,
That is the problem.
Lad, Mr. Mahato will be referring my division bench judgment, lad. Lad.
After this Chandigarh Municipal Corporation really matter, Lordship, everything is being
Place all
এখন
the-
এখন argument করে লাভ নেই। এখন argument করে লাভ নেই।
kindly fix a date for the hearing.
Sir, I have fixed it today.
We did not get any notice for this.
No. I have fixed one
ঠিক আছে, শুরু
particular
করুন।
matter.
তাড়াহুড়ো করার কিছু নেই, শুরু করুন।
One particular matter, and I can assure you, as long as you will not complete those points, I will not close the
Lordship,
hearing.
Lordship.
But
I will.
there will be a caveat. You may not be here, but
A
your
junior.
junior must be here. To start the matter, he will come and you will join him and you will argue.
And
I don't mind.
And in his absence, his junior will pay cost for his not absence.
But if nobody is there for the petitioner, I will not entertain later on.
Lordship.
Those which are in the list. Those which are in the list. Somebody has to be here because it's an interesting point. I can say for myself, had it been in my junior days, had I been a junior in this type of matter, I would have sat, I would have taken note
Yes, ma'am.
so that I can apprise my senior and of course, it's a learning process.
Right.
So that you have to arrange.
Wait.
Lordship, may I be permitted to mention one urgent matter, Lordship?
What is the urgency, sir?
Urgency is that, Lordship, the petitioner is a construction company, Lordship. He have, after getting the tender from the Panchayat, he built several toilets in a Panchayat rural area, Lordship. A single penny has not been paid to him, Lordship.
Where is the urgency, sir?
Lordship, we are out of bread and butter, Lordship.
If the money is paid after 6 years or rather 6 months, sorry,
Lordship, already 2 years past, Lordship, we,
no urgency.
Lordship, may be included in the list, Lordship, when your Lordship convenience the matter will be taken
No
up.
urgency mention after 2 weeks, those will be included in the monthly list of September.
Now, this is a matter of a poor, lad.
Sorry?
This is a matter of a poor. Lad, here, lad, the money on account of lad Indra Awas Yojana has been mistakenly sent to another account, lad.
Mention after 2 weeks? Not now. Let me do some work on this list. Yes, sir.
I have read on a similar issue of Mr. Chatterjee and Mr. Sami Malal, item
Be
number
there,
23.
be there. No date fixing, father. Be there. Today I will start the hearing. Be there. Be there. You will make your submission mentioning the serial number in the list.
23. Lord.
Whatever. I will hear you. No issues.
Well, one matter not listed group 5 Panchayat matter unauthorized construction. It will be not listed.
Is it in the list?
No, not in the list.
Matter ends. You mention after in the month of August.
Or as per your lordship direction, this is the unauthorized construction matter.
In the list,
In the list 161, I think.
see, mention the serial number. For that, no mention is required. Simply all the members are requested to give the slip to my officer. But when you will come to move the application, at least 60 orders I have passed. Take which one suitable for you, make the necessary pencil correction and give it to me. I will not hear it any further.
Yes. একটা list of things.
আর সিরিয়াল নাম্বার যদি কেউ না দেন না, শুনেছেন শুভব্রত ম্যাডাম কোথায়, আজকে মৌমিতা কোথায়, কেন প্রায়ই তো আসে না দেখি, কি কোনো অর্ধেক দিনই তো দেখি, মাসের মধ্যে 2 দিন 3 দিন 4 দিন আসে না। তো কাউকে একটা তো দিতে হবে, ওর জায়গায় কাউকে পাঠাতে বলুন। somebody must come. এইভাবে তো কোর্ট চলবে না, বলুন কাউকে যে আমাদের আসেনি, এসে একজন কাউকে দিতে। ইয়েস, আর শুনুন, সিরিয়াল নাম্বার যদি কেউ না লেখেন লিস্টে, সেই মামলা আপগ্রেড করার কোনো ব্যাপার নেই। ঠিক আছে, ইয়েস, কল দ্য লিস্ট। ডাকুন।
Item number 1. The heading to be mentioned.
So I am for the petitioner, Lordship. Lordship, I have served the copy to the planner.
আচ্ছা, একজন লোক পাঠাতে বলুন, নাহলে ডেকে পাঠান, আমি বলছি লোক পাঠাতে বলুন,
করবে নাকি?
এসিও দিতে বলুন। কেউ একজন এখানে থাকবে, কাজ করবে। প্রতি মাসে 2 দিন 3 দিন করে। কি হয়েছে এটা? আরে টু বি মেনশনড কেন? আচ্ছা,
No, my lord, I am appearing on behalf of the respondent, my lord, state respondent, my lord. Because, my lord, earlier order, my lord, kindly have a look this order, my lord. Two matters, my lord, related two matters, my lord. I have strongly objection to withdraw this matter, my lord. After prolonged hearing, my lord, 2 days, my lord.
No, it's all right,
Everybody is required, my lord, everybody.
1 second.
My lord.
Is there any interim order?
Yes,
Huh?
yes.
They have obtained the benefit of interim order.
That I have to take instruction, Lordship, but there is a
This is the order.
requesting for
No,
withdrawal
no,
of the
first, if you have obtained the benefit of interim order, the law is well settled. You cannot withdraw like it. If you have obtained the benefit of the interim order, you have acted to others' peril, and then he will be prejudiced, he will enjoy the benefit. No,
2022,
that cannot be the law.
several hearing.
Forward us, Kalke. Still, if you have to withdraw the matter, you have to face the consequence. উটকে কি বোকা বানিয়ে হয় বাবা? উটকে বোকা বানিয়ে দেবে? Thank you. At the instance of Mr.
Lordship, I am Mr. Saptoshi Chakraborty. I am
You mention the matter.
Lordship, I am
At
mentioned
the
the matter,
instance of Mr. Saptorshi Chakraborty, learned advocate,
but I am
appearing.
led by Mr.
Please listen to me.
Lordship.
I will not put the gun on your shoulder. Don't worry. Ki appearing for the petitioner, being led by Mr.
Aslam Parvez, Lordship. Aslam Parvez, the advocate.
Aslam Parvez, learned advocate. Comma, the writ petition was mentioned yesterday for non-prosecution. And accordingly, the writ petition appears today under the heading to be mentioned. Paragraph. Mr.
Shuddhadev Adok.
Shuddhadev
Adok.
Adok, learned state counsel, appearing for respondent numbers.
State respondent, my lord. State respondent being WPA number 5022 of 2022.
State respondents sub places an order dated March 12, 2024, wherefrom it appears that both the writ petitions were heard together. এই দুটো মামলার একটাই অর্ডার হবে, হ্যাঁ, 1 and 2 কি কিভাবে আছে, কিভাবে আছে?
Only one matter,
Oh,
one, my lord.
তাহলে বোথ হবে না, কি বললাম? তো সেটা লিস্টে নেই তো, কি বললাম? দাঁড়ান, that the order was passed in this writ petition as also along with another writ petition, namely WPA 8464 of 2022. That is also Panchayat.
Lordship.
Poster. Paragraph. On the query of court, learned counsel appearing for the petitioner submits that the said WPA 8464 of 2022 also pertains to Panchayat, and this court has determination over the same. Poster. Paragraph. The said order dated March 12, 2024 further shows there was an interim order passed in these writ petitions, in the two writ petitions earlier, and the same was extended. Poster. Full stop. Now the petitioner this writ petition, that is WPA 5022 of 2022 seeks to dismissal of this writ petition on the ground of non-prosecution. First up, this court has no knowledge as to what was the interim order passed and whether the petitioner has obtained any benefit under such interim order. Full stop. These are required to be ascertained before allowing this writ petition to be dismissed for non-prosecution. Paragraph. Accordingly, this writ petition WPA 5022 of 2022 and WPA 8464 of 2022 shall appear in the list together under the heading for orders on July 9, 2024.
My lord, one prayer before your lordship, my lord, kindly, my lord, serve all the interested parties. But here, my lord, so many, my lord,
Full
parties
stop.
are here.
Full stop. The petitioner shall serve notice upon all the respondents in both these writ petitions, and shall file affidavit of service when the matter shall be taken up next.
Good.
Ask your senior to come. Otherwise, you might have to face the difficulty.
I have been instructed, lordship. that-
Precisely, but I have to hear the learned advocate, either you or your senior, whoever it is. And if the situation is grave, ultimately I find, then the music has to be faced.
That would be okay.
Item 2,
বোকা বানাতে গিয়ে ধরা পড়ে গেলে মুশকিল।
The spelling of my name wrongly recorded in the order sheet. Like, due to inadvertently my junior it was happened. My name Rajan Dotto, but it was written in the order sheet, cost item. That is the difficulty.
The writ petition appears at the instance of Mr. Rajan Dotto, learned advocate,
Respondent
who
number
appeared in the who appears in this writ petition for respondent number 11. Full stop.
one.
Respondent number 1. Full stop. He submits that his name has been wrongly typed out as Mr. Runjit Dotto in the order dated June 10, 2024. Full stop. Paragraph. The same shall be corrected as Mr. Rajan Dotto, learned advocate. Full stop. Paragraph. Mr.
Also the
Mr. Onindo Haldar, learned advocate, appears for the petitioner.
Ms. Pritha Bhomik appearing on behalf of respondent number 227.
227.
in the cost title, also the in the order portion.
Cost title এ
And
উকিল
also
বাবুর
the
নাম
order
থাকে?
portion, my name is recorded.
Cost title এ উকিল বাবুদের নাম থাকে?
Appearing.
Appearance.
Full stop. The rest of the order remains unaltered and or without any modification.
Much obliged.
item 3,
I am for the petitioner. Petitioner does not want to proceed with the matter.
Take microphone, sir.
Petitioner does not want to proceed with the matter, madam.
Is there any interim order?
But there is an interim order for staying the retirement benefit of the respondent number 13, the defaulted teacher of loan amount, madam. That he has been paid during pendency of the petition after passing the order.
Yes.
No, I have nothing to say. If he has paid,
Where is that?
Written instruction may be kept on record.
Your instruction doesn't matter. Who was prevented from receiving?
My lord, he has not paying the loan amount of the society, petitioner's bank.
Then what happened?
Then, my lord, the writ petitioner was moved before Honorable Justice Amrita Sinha, and my lord, staying.
Show me the order.
Well, kindly see the order, last order first. One order, my lord.
Huh?
Last one order, my lord.
Yes, read on. Yes, then what happened?
Then, my lord, copy has been served. Copy pursuant to lordship's order, my lord, copy has been served upon all the respondents, my lord. Thereafter, after getting this order, my lord, the respondent number 13, the defaulted teacher, has paid the entire amount.
Entire amount.
Entire amount.
Is he appearing today?
No, my lord, today he is not appearing. On that day also, he is not did not appear.
Silence. Ashun.
Written instruction.
The writ petition appears under the heading to be mentioned for non-prosecution at the instance of Mr.
Madan Mohan Rai. Madan Mohan Rai.
Madan Kumar Rai, Madan Mohan Rai, learned advocate appearing for the petitioner. The paragraph. Mr. Pradeep Kumar Rai, learned counsel, appears for respondent numbers. এই পাকাটাকে জোরে করতে বলুন তো কে আছে?
Register 5 and 6. 5 and 6.
Respondent number 5 and 6.
I am for the state.
Mr.
Rajshekar Basu.
Rajshekar Basu, learned state counsel, appears for respondent numbers
1 to 4.
1 to 4, comma 7 and 8. The petitioner being the cooperative the cooperative society. Cooperative society submits that the defaulted loan amount has been paid by the respondent number 13 and the cooperative society has no further claim on this score against the respondent number 13 who obtained loan from the cooperative society. Also, paragraph. Accordingly, the learned counsel for the petitioner has received an instruction, written instruction from the cooperative bank dated June 20, 2024. The cooperative society টাকে না cooperative bank করে দিন সব জায়গায়। Cooperative bank. Comma, the same is taken on record. Full stop. In view of the above, this writ petition WPA 12661 of 2024 stands dismissed as not pressed. Paragraph. Interim order, comma, passed earlier, passed on May 14, 2024 stands discharged and vacated. Good.
Register লেখা ছিল।
I'm led by Mr. Shamal Kumar Das.
You're read by?
Mr. Shamal Kumar Das.
Judgments. Proceed.
Election, na?
This is that matter?
Election lordships.
Four lordships.
আচ্ছা আজ সকালে একটা ফাইল দিয়ে গেল কোথায়?
Election lord.
No.
ওটা আমায় দিন।
Four election নাই বলছে।
The matter is under dismissal heading lordship.
Huh?
Item.
Oh, it is for dismissal. Then why you are saying this?
No. Many items for election commission is also there.
Whatever. If it is for dismissal, it is for dismissal.
Fine. Whatever.
No. If it is for dismissal, it is for dismissal. Ashok. Yes, madam, you are for?
Petitioner Lordship.
Yes. On the prayer of you, what you're praying?
Miss Krishna Yadav.
What are you praying for?
Praying for financial benefits, Lordship.
Oh, it is appearing under the heading for dismissal.
Yes,
I will
Lordship.
dismiss the writ petition.
No, Lordship.
All right. On the prayer of MS
Krishna Yadav. Krishna Yadav.
Krishna
Yadav.
Jadhav, learned advocate appearing for the petitioner. Na tara ke oই দুটো দিয়ে দিন. The last order speaks for itself. Paragraph. Today the writ petition appears under the heading for dismissal. Paragraph. On the prayer of such and such, learned advocate appearing for the petitioner, the writ petition shall appear under the heading motion panchayat in the monthly list of September 2024. Paragraph.
Lord, Mr. Shishanda Bandyopadhyay has been engaged on behalf of state.
Where is he?
Lord, he's on his legs, my lord, before courtroom number 10.
Mr. Shishanda Bandyopadhyay, learned junior standing counsel, appears for the state respondents. Paragraph. The petitioner shall serve notice upon the non-appearing respondents. তারপর ওই যা যা আছে affidavit of service. ঠিক আছে? চলো next. Next.
Item number 5.
My lord, I'm for the petition, my lord. My lord, item number 5 to 10, Mr. Shobhushay Charas is appearing in this matter, my lord. He is arguing in court number 14, my lord.
Monthly list of September. What is your
My
name?
lord, kindly, my lord.
Oh, this is the election.
Yes, my lord.
No, election, but it is appearing under the heading for dismissal. For dismissal, I will not take up. It is appearing under heading for dismissal. That I will not take up. That will be unfair.
A petitioner needs to be present.
That will be unfair. That will be unfair. Any other petition, if I reach, I will take up, but this will be unfair.
Mr. Amol Kumar Sen is appearing for the state, your lordship. My lord, kindly make it known to the my lord.
Better do, let me do one thing. I'm keeping this chunk on tomorrow.
Tomorrow.
Tomorrow হচ্ছে কি বার? না
Thursday.
পঞ্চায়েত কবে নেবো আমি নেক্সট? হ্যাঁ দরকার নেই, আমরা সোমবার রাখি বা মঙ্গলবার রাখি। লিখুন MS
Indrani Roy.
Indrani
Roy.
Roy, learned advocate, led by Mr. Shobhoshachi Chatterjee, learned counsel, appears for the petitioner. তার মাথায় ওই দুটো থাকবে, আগে দুটো প্যারাগ্রাফ, ও দুটো থাকবে কিন্তু প্যারাগ্রাফ। This writ petition relates to a challenge in respect of the Panchayat General Election 2023. Paragraph. MS Sonal Sinha, learned counsel, appearing now. First, Mr. Lolit Mohan Mahato.
No, my lord, Mr. Amol Kumar Sen is appearing in this matter. Item number 5.
In 6 I am.
Mr. Amol Kumar Sen, learned additional government pleader, appears for the state respondents. He has raised the point of maintainability of the election petition. Writ petition. Paragraph. MS Sonal Sinha, learned counsel, appears for the West Bengal State Election Commission, has also raised the point of maintainability. Full stop. Paragraph. Paragraph.
They have made a respondent number 3 as election was in India. I am appearing for election commission in India, but practically we have not.
And record your appearance.
That is
Mr. More the merrier. Mr. Huh? Anuron Shamanto. Learned advocate appears for the
3, my lord.
respondent number 3. The Election Commission of India. Full stop. Paragraph. Today morning, these matters are mentioned, have already been mentioned by Mr. Shobboshachi Chatterjee, Learned Counsel appearing for the petitioner. Full stop. He submits that these writ petitions challenging the election for general election, if can be taken together, then the issue raised by the respondents on maintainability of the writ petition can be decided at one go. Full stop. Paragraph. The Learned Counsel appearing for the respondents before this court today have no objection thereto. Full stop. Accordingly, on the joint prayer of the parties, this writ petition shall appear under the heading Motion Panchayat, within bracket top, on. Tell me 8 or 9.
We leave it on.
Yes, madam?
Yes, madam.
8th or 9th?
Anytime.
8th, Shubhosh.
8th. Monday, na? Monday.
On July 8, 2024. First.
I am appearing on 6, 7, 8.
Arey, matter will be called on. Don't worry. Otherwise, I cannot.
Serial wise.
Ashud, next.
Yes.
Item number 6.
I am for the state.
Give all your appearances. Give all your appearances. Give appearances. This writ petition pertains to challenge. This writ petition, Ligo? 2. Pertains to a challenge in respect of the Panchayat General Election 2023.
1 and 2.
And shall appear under the heading Motion Panchayat within bracket top, along with WPA 16395 of 2023. Okay, serial number 4. 16.
No, 5. It starts from 5.
Then what happened to 4?
5 to 10, my lord.
So 4 ki kollam.
4 monthly list.
Please to fix the item number 4 on in month of September.
Okay. Tale 1660 16660 of 2023. Right?
Yes.
এরপরে যে অর্ডারটা হবে সবকটাই ওই WP 16660 এর সঙ্গে ওইটা থাকবে ইলেকশন হলে। Yes, next.
Number 7.
Well, I am for the
Give appearances, same order. Mention serial number, give your appearances. Same order.
আমি সবতে আছি।
ওই
Election
1660.
Commission.
Next.
well, I am for the state.
Same.
Item number 9.
Same. Give your name, serial number and name. Same. Right.
11 and 16. Yes, I am for the statement.
11, not an election matter. None appears. ছেড়ে দিন. None appears for the petitioner, nor any accommodation has been sought for.
5 to 13 हमारा
11 also election.
Yes.
Perhaps most of them are election. I am appearing on
30, 32, 33, 35, 39, 40.
Let it be
Let them
called.
come, let them come.
The
But
confusion.
11, no petitioner is here.
Do we give our appearances, your lordship, in 11, item number 11?
Doesn't matter.
Not
If I take a decision, it will bind them. Chalo. None appears for the petitioner, nor any accommodation has been sought for. Right? ওনাদের নামগুলো দিয়ে দেবেন, dismissed for default. আর তার আগে মাথার উপর ওইগুলো
11.
দিয়ে দেবেন।
11.
Previous order and this order. Yes.
11 তো
চলো। Petitioner appear করলে it will appear. It might so happen they may lost interest.
Yes.
Next.
Item number 12.
None appears for the petitioner, nor any accommodation has been sought for.
Honorable Kumar Sen is appearing
For dismissal. এই dismissal এর date কবে দিচ্ছি আমরা? Come on.
For dismissal.
Oh, এটা তো dismiss for default.
For default.
Dismiss for default, interim order, if any, stands vacated. সব কটাতে। Next.
13.
Number 13, my lord, I am the election. My lord, 2 days time, my lord, take the instruction, my lord.
It is the election,
Election.
not election. Very well. On the prayer of Mr. Ashish Kumar Datta, learned advocate appearing for the petitioner, the petition shall appear under the heading Motion Panchayat in the monthly list of September 2024. Paragraph none appears for the respondents. Petitioner shall serve notice. So, Jeram kore den. Next.
Number 14.
My lord, item number 14, I am for the petitioner. My lord, I am being led by Mr. Shami Mohammed. This is an election matter. My lord, he has requested me that till Tuesday he will not be here. So this matter can be any
Oh,
other.
sorry, I will keep it on Monday. Then you come and do whatever you do. As a bulk matter will be taken up for one read petition, it cannot be adjourned. Oh, same as 6.
A lot.
Same as 6. Shami Mohammed. Where is he?
My lord, he is engaged in some other court, my lord. My lord may record my name as well.
What is your name? Give me.
Parashar Boidu.
Parashar Boidu. Led by Mr. Shami Mohammed. Chalo, next.
My lord, I am for the state lordship.
এটা কিন্তু ইয়েতে হবে, হ্যাঁ, ওই ইলেকশনের সঙ্গে হবে। Yes, item number
15, my lord, I am for the state lordship.
This is an election matter.
election.
Election matter.
Same as 6. Give your name.
Led by Mr. Kaustubh Bagchi in this.
What is your name?
Debayan Ghosh. Debayan Ghosh.
Mr. Debayan Ghosh, learned advocate, led by Mr. Kaustubh Bagchi, learned advocate, for the petitioner. Give all your names for the respondents. Mr. Mata,
Lordship.
whoever appears, give your names for the respondent by mentioning the serial number. Next.
Mention the serial number also.
My lord, I am for the state
Election.
election. Yes.
None appears for the petitioner, nor any accommodation sought for, dismissed for default. Interim order, if any, stands vacated. Next.
बात तो करो. Item number 17.
17, but I am for the petitioner. Panchayat election.
Panchayat elections.
Oh, 6. Same as 6. Your name, sir?
Mr. Ahmed, S.A. Ahmed.
Mr.
S.A. Ahmed.
S.A. Ahmed. Give slip, sir, mentioning serial number. Next.
Item number 18.
Even if all the orders are not uploaded, because the serial number and appearance will be a troublesome job, then also it is understood that first matter will be uploaded. Few matters definitely will be uploaded on Monday. Next.
Election. Item number 19.
19. None appears for the petitioner, nor any accommodation sought for. নামগুলো ওখান থেকে নিয়ে দিয়ে দেবেন সিরিয়াল নাম্বার ধরে। Dismiss for default. Interim order, if any, stands vacated.
State election commission.
আচ্ছা, ওখানে কেউ নিচ্ছেন তো? নামগুলো নিচ্ছেন তো? সিরিয়াল নাম্বার না থাকলে কিন্তু নেবেন না, সিরিয়াল নাম্বার লিখে দেবে। নেক্সট।
Item number 20. Yes, election.
None appears for the petitioner, nor any accommodation.
Lord, I am appearing on behalf of the union.
Give name, respondent number and your name. আর ওই ইয়ে করে দিন, dismiss for default, interim order, if any, stands vacated. Next. None appears for the petitioner, nor any accommodation has been sought for, interim order vacated.
Election.
My lord, appealing for state, my lord, there was a direction to file.
None appears for petitioner nor any accommodation has been sought for. Mr.
Shishano Bandopadhyay, my lord, has been engaged on behalf of state.
See,
My lord, he's on his
these of matters is not appearing.
my lord, a hearing matter is going on, my lord. My lord, there was a direction to file a report, my lord. We have prepared our report.
Oh, you keep it with you. You will not. What's your name?
My lord, Mr. Rahul Kumar Singh. Rahul Kumar Singh.
Mr. Rahul Kumar Singh, landed advocate, appears for the state respondents, led by Mr. Shishano Bandyopadhyay, landed additional junior standing counsel, landed junior standing counsels. Dismissed. Interim order vacated. No, এটা নিচ্ছেন কি? আপনি কি নিলেন? শুভব্রত।
Dismissed.
রিপোর্ট দেয়নি তো কিছু? ওরা
We have
কিছু
not
দেয়নি তো?
we have not yet
ঠিক
filed
আছে।
our
আপনার কি শরীর ঠিক নেই? শরীর ঠিক নেই আজকে? যন্ত্রণা বেড়েছে? হ্যাঁ। কাউকে নিয়ে একটা বাছারি এমনি এমনি ব্যথা যন্ত্রণা। ঠিক আছে, চুপ বসুন বসুন। আজকে আপনি একটু এগিয়ে গিয়ে দিন উঠে। ভদ্রমহিলা উনি কে আছেন? দিদিমণি একটু করে দেবেন। হ্যাঁ, বাছারি চোট পেয়েছে। হ্যাঁ, next.
My lord, this is my application, my lord, kindly fix the date, my lord.
Election.
Election, my lord.
Monday 6, serial number 6 as 6. কত নম্বর এটা? As 6. Election
matter, my lord.
as 6. What's your name? আগেরটা ওনার নাম কি ছিল? Sir, you give your name.
Yes, I have given my name.
What is your name, sir?
Amitabh Ghosh.
Amitabh Ghosh, learned advocate, appears for the petition. Otherwise, it will be confusing.
No, my lord, I have given.
Yes, thank you. Madam, your name?
Gulshanwara Parveen. Gulshanwara Parveen.
MS Gulshanwara Parveen, learned advocate, appears for the petitioner. Tapuru has 6. Election 6.
Matter, my lord.
6. Then none appears for the petitioner, nor any account is sought for. Dismiss for default. Interim order, if any, stands vacated.
Item number 23.
Your Lordship, I appear on behalf of the state.
On the prayer of Mr. Rameshwar Sinha, learned advocate, appearing for the petitioner, the writ petition shall appear under the heading Panchayat motion in the monthly list of
I appear on
September
behalf of the state.
2024.
State.
State নাম দিয়ে দিয়েছেন। আচ্ছা, নেক্সট হচ্ছে নন অ্যাপিয়ারিং রেসপন্ডেন্টের উপর নোটিশ অ্যামাউন্ট। নেক্সট
Lordship, in item number 20, I appeared on behalf of the respondent number 13 on Lordship.
ইলেকশন
Yes, sir, Lordship.
as 6. না, এটা তো কেউ অ্যাপিয়ার করছে না। নন অ্যাপিয়ার্স ফর দি পিটিশনার নর এনি অ্যাকোমোডেশন হ্যাজ বিন sought for. Dismiss for default. Interim order, if any, stands vacated. Next.
Lordship, item number 20, I appeared on behalf of the respondent number 13,
None
Lordship.
appears for
My
the
name will
petitioner.
kindly be recorded.
Nor any accommodation has been sought. Interim order stands vacated. Next.
Lordship, item number 20, Lordship, I appeared on
the petitioner, my lord.
Election.
My lord.
Election petition.
No.
On the prayer of Mr.
My lord, praying for only.
On the prayer of Mr.
Devorshi Brahma. My name, my lord, Devorshi Brahma. Petition.
না, আপনার নাম কি?
Devorshi Brahma.
দেবর্ষি
Brahma.
Brahma. Take the microphone.
My lord,
On the prayer of Mr. Devorshi Brahma, the writ petition shall appear under the heading Motion Panchayat in the monthly list of September 2024. Paragraph. None appears for the respondents. We notice affidavit of service. Next.
I'm for the petitioner election matter. Kindly fix the date.
Mr.
Bishwajit Hajra.
Mr. Bishwida such and such appears for petition. Tapos 6. Serial number 6. এটা কত হলো? 30.
এটা 30
Yes.
Lordship, I'm for the petitioner, Lordship.
Petition election.
No, Lordship.
On the prayer of Mr.
Sondipan Maiti.
Sondipan Maiti, learned advocate, appearing for the petitioner. The writ petition shall appear under the heading Motion Panchayat in the monthly list of September 2024. None appears for the respondents. Notice. Next.
32 election.
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 Election. Miss MS
Shormishta Boshak.
Shormishta
Boshak.
Boshak, learned advocate, appears for the petitioner. আপনাদের নামগুলো, you give all your names.
Yes.
Serial number 6. Next.
Election.
Election.
Yes. Yes. Your
None
Lordship.
appears for the petitioner, nor any accommodation has been sought for. Paragraph interim order vacated. Next.
34. My lord, I'm appearing for the state. I'm led by
None
Mr.
appears for the petitioner, nor any accommodation sought for. Interim order vacated. What's
My
your
lord,
name?
this is my lord, Miss Shahina Shumi. My lord, this is not an election matter, your
Correct.
lordship.
Oh, that's right, but dismiss. The petitioner is not here. MS
Shahina Shumi.
বুঝতে পারছি না, লিখে দিন। চলো next. Give your name. Give your name.
My lord, I'm for the petitioner. It's an election matter.
35.
My lord, I'm for the petitioner. This is an election matter.
Election matter.
Mr.
Devan Ghosh.
Devan
by
Ghosh,
Mr.
learned
Mustafa
advocate,
Bakshi.
appears for the petitioner. তারপর serial number 6.
I am for the state.
Give your name. Give your name. Next. 36.
Deep your mind. 36, my lord, I'm appearing for the state.
36.
I am praying for time.
আচ্ছা, election.
Panchayat matter, your lordship.
Not election.
Not election. But
On
I'm
the
for the
prayer
state.
of MS.
Ranjana Tolapatra.
Ranjana
Tolapatra.
Tolapatra, learned advocate, appearing for the petitioner. The writ petition shall appear in September monthly list. Motion Panchayat.
I'm grateful, my lord.
Give your name. Give your name. তারপর ওই নন অ্যাপিয়ারিং রেসপন্ডেন্ট না একটা কমন প্যারাগ্রাফ করে দিন, নোটিশ দেবে, অ্যাফিডেভিট অফ সার্ভিস, ও থাকুক না থাকুক করে দিন। ঠিক আছে, নন অ্যাপিয়ারিং বললে ভুল নেই,
Election.
আর যদি
Election
4 জন
matter
অ্যাপিয়ার করে 3
97.
জন করে না তাহলেও ভুল নেই। Yes, which one?
That I appear for the respondent number 9 and 10.
Election.
No, unauthorized construction.
ये dismiss for default. None appears for the petitioner, nor any accommodation is sought for. ওনার নাম দিয়ে দিন। Give your name. Give your name.
Yes, my lord.
Next.
38, no, I'm for the petitioner, my lord.
Election.
No, my lord, this is unauthorized construction.
On the prayer of Mr.
S.A. Ahmed.
S.A. Ahmed, the writ petition shall appear
Abar election.
under the heading Motion Panchayat in the monthly list of August. তারপর none appears for the respondents, ওই non appearing respondents এর উপর দেবেন। আমি অগাস্টেও তো সেম নোটিশ দেবো, তখন ওরা আপডেট করে দেবেন। নেক্সট।
Election. Election.
39. None appears for the petitioner, nor any accommodation sought for. Dismiss for default. Interim order, if any, stands vacated. Next.
Election.
Election.
None appears for the petitioner, nor any accommodation has been sought for. Mr. Chatterjee, I have passed in your matter the orders I have clubbed. I believe the rest of the petitioners have lost interest. They don't appear even under the heading dismissal. So I'm dismissing all those. কি বললাম?
Item 41, my lord. In this matter, my lord, I am appearing for the petitioner, my lord. I am 41. Item 41, my lord.
41.
Yes, my lord.
1 second. 40 কি হলো?
41.
Okay. 41 election.
No, my lord. This is
On
Panchayat
the
matter.
prayer of on the unauthorized construction.
No, my lord.
On the prayer of
It's
Mr.
very short matter, my lord.
On the
Only
prayer of Mr.
Mahadev Sarkar.
Mahadev Sarkar, learned advocate, appearing for the petitioner. The writ petition shall appear under the heading motion
August, my lord.
Panchayat in the monthly list of September 2024. Notice none appears for the respondents. Notice upon non-appearing respondents.
Immediately placed, my lord. August,
Next.
my lord.
It could have been disposed of on the last day had you been there.
42, item number 42, Lordship, I am appearing on behalf of the petitioner.
1 second. Yes.
I'm for the petitioner. There is some urgency in this matter, Lordship.
What is this matter?
I'm suffering a notice of demolition. Lordship, my house has been directed to be demolished. There is a short point involved that whether a house which is constructed under a government scheme can be subjected to demolition.
Pradhanmantri Awas Yojana
Yes, ma'am.
always can be demolished if you are not satisfied.
I will
That's
satisfy your Lordship.
6.60 meter.
Yes, I will satisfy your lordship on this.
Satisfaction is
Any
not on
day,
the part
lordship,
of
kindly
you.
fix the matter, lordship, any day.
No question of like that. It will appear in the monthly list of August at best.
My lord.
On the last day, had you been there, had your junior been there, it could have been disposed of on that day. Now the let other take chance. He will
Lordship.
not.
My lord.
42.
My lord.
On the prayer of
Instead of only prayer of lordship, kindly.
on then September, sir. I'm passing all matters in September. Huh? Very good. On the prayer of Mr.
Lordship,
Pintu Karar.
lordship, kindly.
हाँ
Why he should kindly take lordship, my name.
I don't mind, sir. On the prayer of Mr. That should be the approach of a senior.
My lord.
That should be the approach of a senior. On the prayer of Mr. Shobhushachi Chatterjee, learned advocate appearing for the petitioner, the writ petition since involves an issue relating to demolition of a building,
नहीं
comma, the same shall, there is some urgency, comma, the same shall appear under the heading Panchayat, motion Panchayat in the monthly list of August 2024.
Great.
My lord.
Notice.
If I may. My lord, my item number was 28. I just arrived on
That's
29.
gone. That's gone. Whatever has happened has happened.
My lord, kindly
No, respondent in your matter, Mr. क्यों नहीं आज के अरे बाबा आज के क्यों आज respondent? So petitioner shall serve notice upon the respondent's affidavit of service. Next.
My lord, kindly considers.
Next. Yes.
Lordship, I appear on the respondent number 10 and 12.
43, I am for the petitioner. Lordship.
Wait. Let the people, the members move out. Yes. What is the matter about?
Lordship, relating to the unauthorized construction, Lordship.
Unauthorized construction.
Unauthorized construction.
My lord,
Why for
despite-
orders?
my lord, the
Lordship, on the last
pursuant to
occasion,
the earlier order,
Let me see.
Panchayat was directed to file the report. I am submitting the report on behalf of the Pradhan.
What is the report?
I am submitting.
Is it unauthorized?
This is not, the allegation is not correct.
So it is not unauthorized.
Not unauthorized.
It is authorized.
Authorized by, it is the construction has been done by the Panchayat Samiti, not private respondents. That is for the purpose of public toilet.
Sir, very well. Now, if the Panchayat Samiti has done it by encroaching somebody's land,
No, this is not the correct. This is the land has been gifted by the persons.
have you disclosed
I
everything?
have already disclosed. Kindly see the
Give
inquiry
him,
report.
give him a copy.
I have already
Exception?
exception, Lordship.
Right. Ashu. On the prayer, Acha,
Eight.
on the prayer of Mr.
Mukteshwar Mai,
Mukteshwar Maiti,
on behalf of the Panchayat.
learned advocate appearing for the respondent number 8, comma, the Pradhan of the concerned Panchayat. Time to file report in the form of affidavit.
No, I have filed the report.
That's right. Time to file report in the affidavit stands extended till today. Full stop. The report in the form of affidavit affirmed on June 20, 2024. Filed today in court is taken on record. Full stop. Paragraph. On the prayer of Mr.
Partho Sharathi Das.
Partho Sharathi Das, learned advocate, appearing for the petitioner. Time to file exception to the report stands extended till today. Full stop. The exception affirmed on July 2, 2024, filed today in court is taken on record. Yes. Proceed.
Lordship, as per the report filed by the Pradhan, Lordship, they disclosed a document.
Acha, let me just read my order. Then first I will hear him on his report, then your exception. Matter ends.
Annexure P1 of the report, inquiry report.
Kindly take my order.
Yes, ma'am.
Kindly take a copy of the order dated 10 June 2024. Last order.
Is not. No, copy. Copy of the order is not.
Every day it is placed on server. Every day it is placed on server. 10th June order, today also you don't have a copy. Read it loudly. Read it loudly, sir.
The petitioners complain of an unauthorized and illegal construction of the subject property, drawing attention to an application dated January 31st, 2023, Annexure P2, page 18 of the
Take microphone, switch on. Yes,
that
sir.
the jurisdictional Panchayat authority, in reply to the application filed by the petitioner under the Right to Information Act 2005, informed the petitioners that there was no application for obtaining any sanction plan. No record submitted on behalf of the respondent number 10 and 12, against whom the allegation of illegal construction has been complained of.
Who are the private respondents? 10 and 12? You.
Yes, sir.
Then
Mr. Johad Dotto, learned state advocate, appears for the respondent number 127, submits that the respondent number 8, the appropriate authority to deal with the issue. Mr. Nipon Maithil, learned advocate, appearing for the respondent number 10 to 12, excluding the respondent number 11, submits that there was no illegal or unauthorized construction at the subject permits carried out. There are instances of the public toilet has been constructed by the Panchayat Samiti on the subject land. I kindly appreciate to that. A public toilet has been constructed by the Panchayat Samiti on the subject land. Considering the above submission made on behalf of the parties and considering the materials on record, there is no scope for an interim order to be passed. The respondent number 8 shall file a report
Very well.
in the.
Now you have seen that there was a reply. Let us see that reply at page 21.
Reply just now I received.
No. Reply in the writ petition, page 21. Page 21 from the writ petition.
Page 21 of the writ petition.
Yes, sir.
Yes. This is the reply of the executive assistant.
Kindly read it.
This is the Bengali. তথ্য জানার অধিকার 2005 অনুযায়ী তথ্য প্রদান গত ইংরেজি 7/2/2023 তারিখে আপনার নিকট থেকে প্রাপ্ত চিঠির পরিপ্রেক্ষিতে 8/2005 অনুযায়ী আপনাকে জানানো যায় যে অত্র গ্রাম পঞ্চায়েত নথি অনুযায়ী আপনার আবেদন উল্লিখিত সম্পত্তির উপর উল্লিখিত ব্যক্তিগণের পঞ্চায়েত থেকে পাকা কনস্ট্রাকশন অনুমতি নেওয়ার কোনো তথ্য নাই।
বাস
উল্লেখ
so up to this there is no at least sanction plan.
Sanction plan there are before that, my lord, I draw lord's attention page 18.
I'm coming, sir. So executive assistant said there was no sanction plan. Yes. Now you come to your report today.
Yes.
Show me what you want to show me.
Annexure P1, page
P1.
8.
Yes, sir.
Inquiry report.
Yes, sir.
What inquiry? Lord, at the first instance, I am drawing your attention, paragraph 3, that during inspection, the private disciplinaries are present, but the petitioners are not present. They are intentionally not appeared.
Oh, you did not appear?
Did not appear.
Notice served upon the petitioners was received by the petitioners on the date of 18th June. There is no scope to.
You have taken that point in your reply.
Lordship.
Then?
Thereafter, Lordship, the private next paragraph 4. The
No,
private,
you read it. The
yes.
private respondent
The private respondent submitted document that the plot of land was converted from Sali to Bastu, measuring about 3 decimil of land by the office of the block land reform officer, Kuldoli, South Chobis Parganas on 3rd September 2022. At the instance of the landowner, namely Bhudurani Haldar, Bhuduram Haldar, son of Kedar Haldar, fight case number such and such, copy of the conversion certificate issued by the block land reforms officer.
Is enclosed. All right.
Then that the private respondent also submit that after the death of the predecessor in interest, they have given no objection for construction of community toilet in favor of the Kulpi Panchayat Samiti. South
One
Chowbis.
second. The private respondents also submit that after death of the their predecessor in place, they have given
No objection.
no objection for construction of community toilet in favor of Kultoli Panchayat Samiti over the plot of land lying and situated at such and such. Show me that.
That is drawing lordship. Thereafter, paragraph 5.
No, show me that first.
No objection. That is annexed.
Page 16.
This is page 16.
1/6.
1/6.
1 second, sir.
It is Bengali, my lord.
দান করিলাম। দান. What is the দান, sir?
Gift.
Show me the gift deed.
That is the deed, my lord.
Show me.
Penaks
The gift deed has to be registered. Show me.
This has, my lord, the প্রাপ্ত হইয়া দিয়েছে এক মিনিট মনে করিয়েছেন যে community
An immovable property, if there is no registered gift deed, no gift. That's the fundamental.
This is only collected, my lord. Page
Huh?
16.
Huh?
Only collected page 16. This is a declaration. Page 16.
16.
Which has been available. Page 16. This is a Bengali.
On 10 rupees stamp paper.
It's not this. This is not the stamp paper. This has been which has been.
No, stamp paper, sir. 10 rupee.
That is
non-judicial stamp paper.
That is my declaration.
Huh?
No objection declaration, not the transfer of the lordship's.
No. Then dan does not come.
No objection. Just
No.
like no objection.
All right.
And that has
Do
been-
one thing.
That
Give
is
it to the private respondents. They will deal with it. Then I will take up. Ashu.
and apart from thereafter, Panchayat Samiti resolution has been taken.
Fine for that. That is all right. The moment, two things. If I find the land even has been permitted to do so, and they have no objection in their affidavit, when the affidavit will come, first hurdle is over.
Apart from that, only one thing I drawing lordship's attention.
Second, even if it is a public toilet, there has to have a plan. Because no construction can be there without any sanction plan. If the sanction plan is there, matter ends.
Only things for a moment. The right.
Take the microphone. Take the microphone.
Right to information sought for.
Right.
Right to information sought for as to whether the plan sanctioned in the name of the private respondents. That has been dealt with. Reply has been given. That not plan sanctioned.
Not required, not required. Don't go by technicality. If you require, I can grant you a leave to file supplementary affidavit also. You disclose the plan.
Planned
sanction plan.
Sanction plan, my lord.
Because you are the panchayat.
Panchayat is need not be.
You are the panchayat.
Yes.
You insist everybody that one must have a sanction plan. আচ্ছা এটা আমি বুঝছি না এইসব ঘরে আলোগুলো লাগানো রয়েছে তাও জ্বলে না, কারণটা কি? কে আছে ঘরের দায়িত্বে? আমায় বলবেন, বসার আগে আমি জ্বালিয়ে দেবো সব, কোনো অসুবিধা নেই। আমায় বলবেন, আমি সব দেখে জ্বালিয়ে ফালিয়ে দেবো। আমার ঘর তো অসুবিধার কি আছে? Yes,
By virtue of that, the Panchayat Samiti took the resolution and the sanction.
sir, everything is fine. Everything is fine. You have to, because you are the panchayat. If you find one individual has constructed a toilet in his house without sanction plan, what is your duty, sir?
No, this just must be a sanction
What is your duty, sir, then?
to inform.
If you find that one toilet has been constructed by one private individual in his house without sanction plan, what is your duty, sir?
That is illegal construction.
Demolish. Same principle will apply here.
Here is, my lord, here is the so far the report I find from the records, find from the inquiry report. That is the land which has been used, that has been no objection given by the persons who are the owner of the property, and thereafter the sanction, my lord, the Panchayat resolution has been taken, there are the action plan has been taken, all completed.
So you show me the law that when a resolution has been taken by panchayat to construct a public toilet, no sanction plan is required. Show it to me.
And I have to reply to that.
That resolution is so powerful, it can override the statutory provision. Show it to me.
Yes,
I will accept.
fixing there. I will.
Acha, Ashu. Considering the content of the affidavit report filed by the Pradhan, this court thinks it fit that a copy shall have to be served upon the private respondent numbers
10 and 12.
10 and 12. Private respondents, full stop. Accordingly, Landed State Council shall furnish a copy of the affidavit report to Mr.
Sandipon Maiti.
Sandipon Maiti, learned advocate, appearing for private respondent number 10 and 12, and a copy shall be served upon by the learned state advocate, by the learned advocate on record for the panchayat. Copy shall by the panchayat. The কি বললাম কি বললাম State Council না, accordingly the learned counsel for the Pradhan. ঠান্ডা মাথায় লিখুন, ঠান্ডা মাথায় ভুল বলেছি। Accordingly, the learned advocate for the appearing for the Pradhan shall serve a copy of the affidavit report upon Mr. Sandipon Maiti, learned advocate, appearing for private respondent numbers 10 and 12. Poster. Learned advocate on record for the Pradhan shall also serve a copy of the affidavit report upon the respondent number 11, private respondent number 11. Poster. And shall file an affidavit of service when the matter shall be taken up next. Paragraph. The private respondents numbers 10 to 12 shall file their exception in the form of affidavit to the said affidavit report on or before July 10, 2024. Full stop. Paragraph. The Pradhan shall also be at liberty to file a supplementary affidavit disclosing the necessary sanction plan for construction of the said public toilet on the land, on the subject piece of land. On or before July 10, 2024. Upon a copy being furnished to the learned advocate appearing for the petitioner and the learned advocate appearing for the private respondents. Poster. The writ petition shall appear under the heading কিসে আছে এটা? For orders on July 17, 2024. Thank you, sir.
Item number 44.
My lord, I am for the petitioner, my lord, led by Mr. Madan Mohan Rai.
Led by Mr.
Madan Mohan Rai. He is now at a code number of 14, my lord. I am paying for short pass for one.
Passed over for the day.
Or lordships, 1 week.
Sorry,
Lord, in place of only day, my lord, I accommodation 1 week.
accommodation?
For 1 week. I got no, I work for the private respondent, I got no instruction. No, kindly 1 week.
Ashu. Mr.
Madan Mohan Rai.
Your name?
My Horipodo Nayak.
Mr. Horipodo
Nayak.
Nayak has prayed for an adjournment on the ground that Mr. Madan Mohan Rai, learned arguing counsel,
Private respondent.
on the ground of Mr. Madan Mohan Rai, learned arguing counsel, full stop. Paragraph. Mr. Mukteshwar Maiti, learned counsel, appearing for his private respondent numbers. This is unauthorized construction.
No,
Cooperative matter.
Oh, cooperative. Bolo.
13.
Respondent number 13. Private respondent number 13. Prays for some time
And my lord, I am for the state.
to obtain instruction from his client. Paragraph, Mr.
PK Bhattacharya.
Srika Bhattacharya, Learned State Council, appears for respondent numbers
7, my
7.
I am for 5 and 6.
Mr. Pradeep Kumar Rai, Learned Council, appears for respondent numbers 5 and 6. Paragraph. For the ends of justice, the writ petition shall appear under the heading for orders on July 17, 2024.
July 17.
Next.
Assigned matter for hearing, item number 45.
But I am for the school authority, my lord. I am praying for one accommodation for the.
No one is for the petitioner. Why do you worry? None appears for the
My lord, Mr. Shanali is for the petitioner. There are two matters you lost. It was hard.
Convince him.
There are two connected matters. Your lordships on the last occasion fixed both the matters at a time. But first, my lord, we couldn't appear because of the strike, all that.
So
So
I'm
that matter has been fixed on the 8th. So this should be taken
on first.
on first. My lord, first Monday.
I have not passed any order on first.
Simply adjourn the 20, my lord, 8th.
There must be some, no, only the dismissal matters were orders passed. Not a single matter, unless parties appeared, I have passed any order.
On first, your lordship was dismissed.
Of course,
Probably, my lord, the matter was.
those were appeared third, okay, those were appearing under the heading for dismissal after 3
No,
opportunities.
that was not for dismissal.
Then I have not dismissed. I have not even passed a single line order. Only, you know, Mr. Sannal, the practice of this court, I give opportunities. If no one appears, then on the third opportunity, I keep it, or second opportunity, I keep it under the heading for dismissal. Because and it order records previously on such and such occasions, no one appeared. But other matters, I have not touched it.
So this was, if I'm not wrong, under the hearing assigned.
I have not even passed a single order.
তুই ডিসমিসাল বলছিস কেন? আমি শুনলাম কবে লিস্টে?
Item
After
number
the heading?
29.
29 of the combined.
Combined list.
Hearing malad under the assigned matter.
Can't be. Can't be.
বলছেন ডিসমিসাল। তো তুই বাঁচাসনি কেন?
আমি ছিলাম না তো।
ও তুইও আসিসনি আমাকে দিছিস?
Yes. Why will it not be dismissed? Kindly see what is written in the list. I have rightly dismissed.
কি বাবা?
Rightly dismissed.
Malad kindly allow rightly the repetition.
I am rightly dismissed, sir. That's why I said. Because these were all after 3 occasions. বসে পড়ুন আপনি. These are all after 3 occasions. And I have rightly dismissed. I have no qualms.
No, I hope your lordship will always be allowing the repetition rightly, not dismissing the repetition rightly.
I have, sir, I grant at least 2-3 opportunities.
So then I have to take up an formal application. Kindly adjourn it for a week. Kindly adjourn it for a week.
No,
because that both the matters are assigned.
And
Because I appeared, I rather
even-
called upon my learned friend.
even when an application for restoration comes, it remains there, I pass my order.
ফাইল নামিয়ে দেয়নি তো আমার? হুম?
সই হয়ে গেছে।
সঙ্গে সঙ্গে নামিয়ে দেন নাকি? তাহলে গেল।
Because I still, I.
But on that particular day, your lordship.
Why not?
Malad, I tell your lordships, if I come before your lordships on that day, in presence of the respondent and extension of interim order, even the honorable court do not do that. That's why I have failed to appear. Because I am totally against any adjourn, malad, any court, malad, rising, all that. That's the happen.
Mr. Sanyal.
On the just before that day, your lordship.
Mr. Sanyal.
This is malad, we are
Mr.
suffering
Sanyal,
like this.
The moment in my list, matter is placed under the heading for dismissal, unless petitioner appears, I dismiss. The petitioner appears and say a single word, adjournment only. No question why, when, how. I adjourn. Where is the difficulty?
Difficulty I'm not. Difficulty I couldn't appear. Delivery is not delivery.
No, sir.
No,
Mr. Sanyal, even before that day, 2 occasions matter appeared, nobody appeared for the petitioner. Then only on that day it appeared under the heading to be mentioned for dismissal. Show him any order. আজকে অনেক order হয়েছে, একটা order দিয়ে দিন, ফাইলে দেখান.
I accept that, your lordship.
I mentioned even if you see my order of dismissal, please take it out for your satisfaction. From the,
I'm saying on that particular
it says
day.
no. It says the previous order speaks for itself.
I get your losses. I know
Then
that.
today the matter appears under the heading dismissal. Then none appears and is dismissed.
On that particular day.
Where is what was the
Our
auspicious
council
day?
resolution we did not. That-
but
on the that your losses, we are not allowed to car parking, all that. And the
no.
misguide কেন করে করছিস? Bar council.
Sir, leniency should not be taken for granted.
No, I don't want any leniency. I do not want.
No,
Your lordship,
I believe in
remember
leniency.
that. Whenever there is a resolution, I will appear, I will argue, your lordship accept. Your lordship will not. Because a resolution, both sides not there, your lordship. Why should I, my lord?
Correct.
I will not accept that.
Correct.
Do that, your lordship.
Correct.
I will
But,
do that.
but there was no resolution forwarded.
What could I do, your lordship? I
Just
could have
take out-
flouted it, and I have flouted.
Just take out 1-page application.
And my lord, file will not be available.
Wait.
This
You
file
take out an application. Let me see how the file is not available.
Sure.
Ashut. On the joint prayer of so should I record joint prayer of the parties? This matter?
Yes, do that. Because I have to take.
On the joint prayer of the parties, the writ petition shall appear on. Give me a date on. You choose the date.
Just
রেগেলা
16 তারিখ করুন 16 জুলাই করে
16 তে করে লাভ
15 জুলাই
18 your losses keep it on 18.
17 জুলাই ছুটি
বিশাল বড় মাপ।
Yes.
Matter, my lord.
ও তুমি দাও, একটু দাও, নিয়ে দেবো। জাজমেন্ট টাজমেন্ট দেখাবি তো? দেখা দেখা
Yes.
This is a matter, my lord, pertaining to the recruitment process of 2020 conducted by the West Bengal Board of Primary Education for
Assign.
appointment in the post of primary teacher. Assign hearing matter before your lordships. The recruitment process of 2020. First of all, my lord, kindly look to the notification once.
No, first you just give me a nutshell. Give me
Yes,
in a
yes, yes,
nutshell, then I will go wherever you want to look at, I will
Yes,
look
yes.
at.
The
Then-
main issue of the writ petition is that the reserve category candidate who availed of the benefit of reservation in one stage of the process, they cannot be placed in the minor general category. This is a settled principle, my lord. Here in the recruitment process of 2020, I can able to show before your lordships that 2,400 above candidate, my lord, who avail the benefit, but they are placed in the general category. The petitioner, my lord, most of the petitioners, 90% petitioners belongs from general category.
Naturally, their space is encroached.
Yes. And another thing, my lord, they all, my lord, the reserve category candidate who as the petitioner in the writ petitioner, they got 90 marks in the TET examination, and they have not availed any benefit of reservation so far as the petitioner is concerned. Now, my lord, what has happened, my lord? The person, my lord, who availed of the benefit of reservation, they are placed in the general category. To that effect, my lord, I am challenging the panel of 2020 recruitment process. That is the subject main text of the matter.
2020
recruitment process, where, my lord, the panel is published on, my lord, 17th March 2021.
And your writ petition?
Writ petition is, my lord, filed on, my lord, 18 January 2023. Because because, my lord, the result in
Panel expired on?
Panel expired on, my lord, according to, my lord, West Bengal Board of Primary Education, March 2023. Before expiry of the panel, I filed the writ petition. And moreover, the marks which is provided by the West Bengal Board of Primary Education in the month of November 2022, after in compliance with the order of the another writ petition, my lord, they published the marks of 2016 recruitment process appointed candidates and the marks of 2020 recruitment process appointed candidate. After getting the, my lord, information, the result, my lord, I can ascertain the defect in the preparation of the panel. As such, my lord, the reserve category candidates are placed in spite of availing one reservation benefit. That is the whole subject matter of the writ petition.
Now you proceed in your own way.
Yes. Kindly, first of all, my lord, kindly look to, my lord, page 342, where the notification I have annexed, recruitment notification. This is recruitment notification dated 23rd December 2020.
Slowly, sir.
কত পেজ বললি?
342.
Which page, sir?
Page 342.
Dated, notification dated?
Notification dated 23rd December 2020.
Notification for selection process.
For selection process for appointment of primary teachers.
Page?
Page 342.
342.
Yes, sir. Kindly come to page 342 once.
Yes, sir.
Kindly look to the, my lord, the reservation quota middle portion, top. Bold letter is there, reservation quota.
Serial, go by serially. Vacancy,
Then
scale of
reservation
pay,
quota.
qualification.
Then vacancy, then my lord, reservation quota.
Okay.
Merit. The reservation quota for the candidates belonging to the scheduled caste, SC, scheduled tribes, ST, other backward classes, OBC A and OBC B, exempted category EC and ex-servicemen, and for physically handicapped candidate shall be maintained as per the existing reservation rules as framed by the competent authority. And kindly see the then scale of pay.
Scale of pay.
Then qualification, now relaxation point.
Relaxation.
The reservation relaxation mentioned in the notification as candidates belongs to belonging to reserved category. Candidates belong to the scheduled caste, scheduled tribes, other backward classes, exempted categories, and ex-servicemen, and for physically handicapped candidates shall be allowed relaxation up to 5% of the qualifying marks. That is the, my lord, notification for relaxation, my lord, 5% in the qualifying marks. That is, my lord, TET examination, teacher eligibility test.
Okay.
Originally, my lord, the general category candidate for general category pass mark is 90 marks, and for reserve category candidates, my lord, previously it was 83 by the court of the order. Now, my lord, it is 82 in TET qualified marks, my lord, for reserve category candidates. These reservation, my lord, relaxation has been mentioned in the recruitment notification. Now, my lord, kindly come to, my lord, the merit list published on 17th March 2021, which is at, my lord, page 417. Merit list.
17 March.
17 March 2021.
Page
417 onwards.
Page
417.
Yes.
417, sorry.
Yes.
I am placing before your lordships, my lord, to establish that the result, my lord, was published, merit list was published by the board without detailing the marks of the candidates. Kindly see, my lord, the roll number, then names, caste category, and the rank. Nothing has been given, my lord, in the month of March 2021 by the West Bengal Board of Primary Education. Subsequently, it was provided in the month of November 2022, the result, detailing the marks of the appointed candidate.
panel.
Show me.
Panel to tumra daoi.
Etai to panel amar.
Eta panel nahi. Ei tumi na ei.
Marks provided November 2022.
Which is at page, my lord, 437 onwards. Okay.
432.
37, my lord. Kindly see, my lord, the heading, breakup score of panel for the recruitment process of 2020 against 16,500 vacancies in respect of the each impanel candidates. From there, my lord, we came to know that those candidates who reserve category candidate who availed of the benefit, because, my lord, the marks of TET score, kindly see Punab Kumar Ghosh, 6, serial number 6 from top.
Yes.
he obtained TET score 2.966.
কাকে রেফার করছিস প্রথমটা?
প্রণব কুমার ঘোষ, দেখো 6 নম্বর সিরিয়াল 6.
পেয়ে গেছি। ঘোষ বলে তুই দিবি না?
He secure less than 90 marks. Then his percentage of marks 2.966. And those who above 90,
Pranab Kumar Ghosh,
obtained by the OBCB,
then what 90% you are saying?
those candidates who
TET score 2.96.
like, as such, my lord, he got, my lord, less to 90%, 90 marks.
How do I know?
Well, calculate total marks is 150. If the average is there, then percentage of marks are 2.966.
No. The TET score 2.96 means less than 90.
Less than 90.
Where do you get that? How do you get that?
The calculation,
What
because
is
my
the
lord,
calculation?
total marks is 590 by 150 marks total.
Alright.
And 90 is the pass marks for general candidate, general category candidates.
No. Total marks 150.
150.
Then 90% of it is
Pass mark
135. 135 is the 90%.
90%, 90 marks, not 90%, 90 marks, only 90.
Acha 90.
Out of 150, 90 marks is the qualifying marks for general candidate. If I take the percentage, then it would be 3%. That is the weightage of marks, TET score.
সারাদিন চলবে এত মোটা ব্রিফ।
Qualifying marks is 90.
90 for general category candidate.
এই তুমি বসে বসে না
চ্যাটার্জি ঘোষের পেছনে লেগেছে আর রেশমিও ঘোষ।
স্যার
Right.
ঘোষকে দেখাতে
Nine.
রেশমি ঘোষের পেছনে লেগেছে।
So TET score 2.966.
So, my lord, the Pranab Kumar Ghosh availed of the benefit of reservation in the TET examination. Until unless
Acha, unless he gets 90.
90,
So I am confused. If he gets 90, then what should be the TET score?
3 weightage.
That what do you get?
Kindly see the Bishwajit Maiti, number 5 serial. His TET score is 3.6066.
Correct.
As such, Bishwajit Maiti has secured the 90, above 90 marks.
Where do I get that? How do I know
The
that?
calculation of weightage is the TET score is that 3% for 90 and 2 point something
Less than 9. All right. Who's the village? TET score 3 is equal to 90 numbers.
90 marks.
All right. So whoever gets less than 3, less than 90.
90.
Which means not a qualifying marks.
No.
Which means if he belongs to a reserved category, he will get that 5% benefit. And gets a qualifying round.
Yes.
All right.
Now, my lord, kindly look to by the recruitment rules 2016.
Where is that?
Page 387 onwards.
20 কত page?
387.
387.
Recruitment rule 2016.
2016.
You are governed under 2016 rules.
Yes.
Page
387 onwards.
আমরা বেদ বাক্যের মতো
Kindly come to my lord 390.
জীবনে কোনোদিন আমরা জালি করিনি, বেদ বাক্যের মতো মেরেছে। অর্জুন সিং পেলি নাকি স্যার?
Three,
390.
390.
390.
387 it starts.
Yes, yes, yes. 390 relevant.
1 minute. $390 is relevant.
390.
Rule?
No, this is note 6. Rule 6. Under rule 6, note 6. Kindly see.
অ্যাডেও দেয়া আছে দেখালেই তো অ্যাডে আমার কেন
Yes.
Note 6, left portion. Candidate belonging to reserve category.
Take the microphone properly.
Yes, yes, yes. Candidate belong to reserve category. Candidates belonging to scheduled caste, scheduled tribes, other backward classes, exempted categories, ex-servicemen and for physically handicapped shall be allowed relaxation up to 5% in qualifying marks. Then kindly come to next page, 391.
Note
The table A. Table A portion, this is the classification of marks of TET exam, the selection process, where for teacher eligibility test, 5 marks is there. Kindly see 5 marks in the Roman 4, teacher eligibility test.
Yes.
So the teacher eligibility space is a vital factor to get an appointment in the post of primary teacher. Not that TET qualification is the primary condition to appear in the selection process. Those candidates who TET qualified, they can only apply for the selection process. But
It's
here,
like
my
a
lord,
prelim and final.
final. So, my lord, the TET marks also vital factor in ascertaining the merit of the candidate.
Every head is vital factor
Yes,
under that table A.
yes. As such, the relaxation in TET, also the paramount and the first factor, the relaxation, which is availed by the reserve category candidate, they cannot be placed in the general category. That is my contention.
Show me that judgment of Supreme Court. I believe there is one. That once a reserved category candidate
Yes, yes.
has availed of the benefit of reservation, he shall remain under that category only.
Yes, yes, yes.
He cannot shift his
I have,
category.
I have, my lord, I come later. But kindly see, my lord, another provisions of the rule, which is at page, my lord, 395. Kindly see rule 20.
Compassionate upon.
395.
No. Proviso clause, in proviso clause, it is also mentioned, although is it compassionate appointment, but my lord, as applicant seeking appoint in the primary school teacher under the category shall be allowed relaxation of 5% in qualifying marks in TET.
No, it is a compassionate
Compassionate
appointment.
appointment.
Not required.
Yes, yes, yes.
Where is the compassionate appointment?
Then, my lord, kindly look to, my lord, my paragraph, my lord, of the writ petition, paragraph number 27 onwards, where the case made out by the petitioners.
এখান থেকে কোথা থেকে শুরু হয় বুঝতে পারি না।
I'm coming after 5 minutes.
তোমাকে আমি বলে দেবো।
5 minutes.
5 minutes. তোমরা চাকাবে 10 minutes. I have to go to canteen, then prepare, then come.
Dakun. Bahadur. Yes?
এই বলো।
কেন রিলিজ কেন?
stand release for till at
I
150.
will not say anything. If I find nobody is there, I will place it for dismissal on some other day. Unless, of course, accommodation is paid for. If somebody pays for any accommodation, I always grant.
For the benefit of the member of the bar, one more rider. Not in the day your losses when the bar taken a resolution. Dismissal. Not.
That dismissal was under the heading dismissal and previously 3 occasions none
Even
appeared.
under the heading
No.
dismissal, yes, sir, if the bar taken a resolution, what am I?
No, but takes a resolution, then fine, but no resolution.
That was the situation.
No,
Bar council.
no. Show me a resolution was communicated to us.
Yes, yes.
Show me the resolution.
That will be my ground of restoration. But took a resolution. Bar council following. Even bar was not open. Bar was not open.
All right, you come up with your application. But be careful when you take a ground in your application, because if you take a ground in application which comes very well, you come up with annexing that. I will see. You come up with an annexure. Come up with an annexure that it was communicated to us.
Oh, communication.
Of course.
Communication.
Of course. Ask anyone whenever a resolution is communicated to us. I go on dismissing.
এটা কিছু করেনি সার্কুলেট হয়েছে
Okay, let's go.
Some risk. On that side, no restriction. This side, some restriction.
No, discussion is always.
Some restriction.
But parent body took a resolution. Bar council.
Sir, what had happened to the order? Single bench order?
Single bench.
That was under challenge, and then what was the order? What was the order, sir? Let us not go into it. Let us not go into it.
Kindly come to paragraph 27.
27.
Which is at page 264.
Writ petition.
Writ petition.
Para 27.
Yes.
Chaliye din.
Page কত রে?
Page 264.
No.
পেপার বুকের মধ্যে হয়ে গেছে বুঝেছো? After scrutinizing the entire merit list dated 17th March 2022 and the list provided by the West Bengal Board of Primary Education dated 28th November 2022, your petitioners are able to find out the discrepancies in...
Once again, 27.
27.
Yes, read on, sir.
After scrutinizing the entire merit list dated 17 March 2022 and the list provided by the West Bengal Board of Primary Education dated 28 November 2022, your petitioners are able to find out the discrepancies in preparation of the panel of 2020 recruitment process, which are as follows. Roman 1, I have given one by one candidates details, their marks and the benefit
which you have already submitted by showing the relevant documents and taking up sample candidate.
Yes.
That is stated in detail.
According to the list dated 17 March 2021, one Punab Kumar Ghosh, having roll number such and such, secured 3rd rank in the unreserved category merit list. The said Punab Kumar Ghosh is originally an OBC B category candidate. But after getting the marks obtained by the Punab Kumar Ghosh in his state examination of 2014, the details of marks provided in terms of the notice dated 28th November 2022, the petitioners came to know that he secured 89 marks in TET examination of 2014, being a reserve category candidate under OBC B category. he availed of the benefit of reservation securing lesser marks in TET 2014 examination, but he qualified only because he availed the benefit of the marks as OBC B category candidates at the time of passing TET 2014, the written examination. But he is illegally placed in UR category merit list in violation of the policy of UR unreserved category. Merit list in violation of the policy of reservation. Your petitioner found from the list of 28 November 2020 that the Pranab Kumar Ghosh, being a OBC category candidate, availed of the benefit of reserve category on account of lesser marks, and as such was placed in the list dated 28 November 2022 with less than 90 marks in TET 2014. It appears that his state course is 2.966, which I have shown before your lordships, beyond 90 marks in TET 2014. And as such, his name should be appeared in the merit list under OBC B category, being the reserve category candidates. It is settled position that there is an express bar on migration to unreserved category category of those reserve category candidates who availed of the relaxation marks in TET qualification. It is stated that relaxation of marks in respect of reserve category candidates in written examination of TET 2014 amounted to giving concession to reserve category candidates, and after availing such concession, they were not entitled to migrate to general category, as because the concept of relaxing pass mark in TET for the reserve category candidates be treated as availing the benefit of the recruitment, and the benefit have to be those which have direct relation to the recruitment, because the 5 marks is allocated for the TET examination in the recruitment process and are relatable to the dual relationship of employer-employee, and such benefit must occur from and should be the post-level playing field. According to the West Bengal Primary Teacher Recruitment 2016, the weightage of TET marks is given in preparation of the final merit list, and the appointments are offered in terms of the merit position of the merit listed candidates. The said Pranab Kumar Ghosh secured eligibility qualification, being TET qualified candidates under relaxed norms, mean for OBC B category. As such, he should not be placed in the unreserved category merit list for appointment in the post of assistant teacher in the primary school in respect of recruitment process of 2020. The said Pranab Kumar Ghosh got appointment being a primary teacher by the respondent board in violation of the reservation policy. That is the instances I elaborately stated. Now, my lord, kindly the case of one Priyanka Shaha,
Not
similar case. I shows, my lord.
Any affidavit in opposition?
Yes.
Actually admitted.
Show me from opposition.
Yes.
How have they dealt with?
Yes.
27 point Roman 1.
Yes.
No, factually admitted. I'm admitting.
AO para. AO para.
Paragraph, kindly look to paragraph 11B.
11B বার কোন opposition?
কোথায় opposition?
11A, sorry, my lord, 11A. 11A, it is stated that.
1 second. কোথায়
Page
opposition?
4. Page 4. It was affirmed by one Ranjan Kumar Jha.
Three, 4, and 5 opposition. R 3, 4, 5.
Yes. Respondent number 3, 4, and 5.
Paragraph
11A, page 4.
Yes.
Now, my lord, this stated, my lord, by filing the affidavit that save and accept what are run for the record, I category deny and dispute each and every statement in paragraph such and such. They denied all the statements and put the petitioners to strict proof thereof. I also state that the statement and or submission of the petitioners in regard to the candidates belonging to SC, ST, OBCA and OBCB who having availed of 5% relaxation have passed state 2014. They admitted that they, after relaxing norm, my lord, they qualified in the TET 2014. Now cannot be migrate to unreserved general category vacancies from their own respective categories at the time of recruitment empanelment and appointment in selection process of 2020 is utterly misconceived.
What is the sentence?
Sentence, my lord, they're denying the contention.
Where is denial? Read it.
I'll kindly see, is misconceived. Cannot be migrate. Kindly see, my lord,
I also state that the statement of submission
cannot migrate to unreserved category. That
cannot migrate.
Cannot migrate.
So
to
they
unreserved.
admit cannot migrate.
Cannot migrate to.
They admit that.
That is utterly misconceived. Kindly see the last
Cannot
line.
migrate to this. And appointment in the selection process.
The contention taken by the, my lord, placed by the petitioner in the writ petition, they denied the same.
All right. Then
kindly look to, my lord, next paragraph. What they have stated.
Same thing.
No,
it's a different. All right.
Contention, kindly see. The relaxation in TET marks.
Yes.
Would not amount to concession in recruitment process. But in the recruitment rules, there is a provision for allocation of specific marks for TET examination. 5 marks. Now they have stated that relaxation in TET marks would not amount to concession in recruitment process. But the marks of the TET examination is the vital factor for the recruitment process in terms of the recruitment rules also. I kindly see passing of TET is a condition of eligibility for appointment as an assistant teacher in the primary school.
All right. You show me from their affidavit or from the document which they have relied upon from their contention that they have said that migration is possible. They have said migration is possible. In support of that, what have they said?
They have said, kindly look to, my lord, page 5. Their contention, the playing field started from the recruitment process, not the TET examination. From the TET examination. Kindly see, my lord, page 5, 3 lines from top.
Yes, read on.
On the heads is marks in TET.
One second.
So far,
no, now.
So
Merit
far,
list of successful candidates is to be prepared on the basis of marks obtained under the different heads
as per the rules.
Then
one of the heads is marks in TET. So far as primary school teacher recruitment rules 2016 is concerned, weightage of 5 marks of the TET are to be assigned to each candidate as per note 4 of rule 8 sub rule 3, that is the percentage of marks obtained by a candidate in TET examination shall be reduced proportionately to marks obtained out of 5.
Where is that rule?
Rule, my lord, I have shown, my lord, before your lordship, my lord. Kindly see, my lord.
Reduced to 5. Tick.
And that is proportionately, my lord, given. My lord,
your case is not that. Your case, whatever you have done, you have done. I don't have any quarrel. That is petitioner's case.
Yes.
But once they have taken, let's say, they cannot take double advantage. So, if they are allowed to take double advantage, then your petitioner will suffer double jeopardy.
Double jeopardy.
That is not permitted in law.
No.
Unjust enrichment. That is your case.
Because the marks obtained in the TET of a candidate is vital.
What you say, what you have to show that once they have availed of the benefit of a specified quota, at every stage they cannot take that benefit. And once they have availed of the benefit as a reserved candidate, they will throughout they have to be treated as a reserve category.
Not the general category.
So show me that.
Yes, yes, yes.
Not from pleading. Those are basically rules and law.
Yes, yes, yes.
Show me. That is the core issue.
Yes, yes, yes. একটু দাঁড়াও। First of all, I am referring a judgment, my lord, of 2019, volume 7, Supreme Court cases.
Proposition, crystallize the proposition, give me the judgment.
The proposition is reserve category candidate availed of the benefit of reservation. He cannot be placed in the unreserved category. The same proposition. 2019, 7.
1 second.
2019,
Reserved
volume 7.
candidates.
হেরেছিলি এটা দেখি বলে দিস
তুমি বলে দেন 383 তোমার judgment
Yes, sir. Page, citation.
Sir, 2019, volume 7, Supreme Court cases, page 383. এটা নীরব কুমার। Paragraph 17, 22, and 33.
Show me the facts.
Kindly see.
এগুলো শুভব্রত একটা সাদা ফাইল করবেন আর মাথা শুনুন এইভাবে লিখতে হয় আমার প্র্যাকটিস এইখানে লিখে দেবেন পিটিশনার আজকের তারিখ ন্যাচারালি পিটিশনার প্লেস করছে পিটিশনার আজকের তারিখ দিয়ে আমায় দিন আজকে কত তারিখ 3 তারিখ 3 তো 24
রথযাত্রায়
ওই হবে
Your full name? Your full name? Dibbendu Chatterjee.
চ্যাটার্জি বামুন বলি তো ওবিসির এগেইনস্টে
এই আবার সেই শুরু হয়ে গেল এগুলো কি ডিজিটাইজড এগুলো একটা 15 পরে তো দেবো কি দাঁড়াও ডিজিটাইজড ডেটা
না না এগুলো
যখন সফটওয়্যার বলে ছেড়ে দিচ্ছি
Yes. Let us read the.
Kindly see paragraph 2 once. The facts of the case. The brief fact of the case, which are necessary for the deciding this appeal, are Gujarat Public Service Commission had issued an advertisement dated 1st March 2010 and corrigendum thereafter for 47 post of assistant conservator of forest and 120 post of range forest officer. As per the said advertisement and corrigendum, total 84 posts were to be filled in from unreserved category candidates, and out of the said 84 posts were to be from the unreserved category candidate. Out of the said 84 posts, 26 posts were reserved for the women categories, and 48 posts were to be filled up in from socially and economically backward classes category candidates. Out of 48 posts of ACBC candidates, 18 posts were reserved for women candidates and 9 posts were to be filled in from scheduled caste category candidates, out of which 2 posts were to be reserved for women candidates. Similarly, 26 posts were to be filled in from scheduled tribe category candidates, out of which 8 posts were reserved for women categories. It was also stipulated in the said advertisement that 25% of the vacancies shall, as far as practicable, be filled up by appointing candidates who possesses BSc degree with forestry as the principal subject, GPSC Gujarat Public Service Commission had stipulated in advertisement that the candidates should submit their online application form 1st March 2010 to 6th April 2010. The detail about the education and qualification, age, mode of examination, as well as the steps to submit the application have narrated in the advertisement. GPSC conducted preliminary test on 30th May 2010 and main written examination was held on the such and such date. The result of the main written examination was declared on 21st May 2014. Where 505 candidates who cleared the main written examination were called for physical measurement test. Personal interviews were conducted from such and such date. The applicant submitted an application in the category of SEBC. He successfully passed in the examination conducted by GPSC. In the list of selected candidates published on 25th September 2014, he was shown at the serial number 138. It is the case of the appellant that while preparing in the merit list, GPSC has ignored the judgment of this court in Jitendra Kumar Singh versus State of UP. Therefore, the appellant filed the special civil application number such and such before the learned single judge of the High Court of Gujarat, challenging the correctness of the aforesaid select list. The learned single judge, by his order dated 11 June 2015, allowed the application in the following terms. Such and such, the action of considering the meritorious reserve category candidates within bracket who secured their position in general and open category on account of their performance in their respective reserve category only because they availed of the concession, which cannot be considered as relaxation in merit, also set aside since it is found to be contrary to the decision of the Honorable Supreme Court in Jitendra Kumar Singh. Being agreed by and dissatisfied with the order of the learned single judge, GPSC filed later patents appeal, praying for setting aside the order passed by the learned single judge. The division bench of the High Court, by order dated 15 March 2017, has allowed the appeal and set aside the order of the learned single judge as Nirav Kumar Dalpat by Makwana case, SPC Online, Gujarat, paragraph 52 onwards. Keeping in view of the decision rendered by the Honorable Supreme Court as well as this court discussed herein above, and in view of the discussion made us in the aforesaid paragraphs, we are of the opinion that the state of Gujarat has framed the reservation policy by the government resolution of 11th February 1986 and circular dated 9/20 such and such, as well as in view of the statutory provisions of recruitment rules of 1967, rules of 2007, 2008 and 2009. We hold that all those candidates belonging to a reserve category, if they avail the benefit of age relaxation, the same is to be considered as relaxation in the standard, and therefore such candidate who got the benefit of age relaxation are not entitled to considered in the general category, and their cases are required to be considered for the reserve category cases only. Thus, the decision rendered by the Supreme Court in Jitendra Kumar Singh would not be applicable of the fact of this present case, and the relaxation of age in view of the policy of the state government can be said to be relaxation in standard, and the same cannot be considered to be concession. We answered the question posed for the consideration accordingly. In this appeal, the appellant has challenged the legality, correctness of the aforesaid order of the division bench of the High Court. We have heard such and such for the appellant and the petitioner. Mr. Garg submits that the relaxation of concession in age granted to the candidate in initial stage only to enable a candidate belonging to reserve category without granting him any preferential advantage in the matter of selection cannot be treated an incident of reservation under Article 16(4) of the Constitution of India. The circular dated 29 January 2000 and 23rd July 2004 issued by the government of Gujarat clearly shows a concession in age in the matter of selection to a post which cannot be treated as an incident of reservation. Therefore, the relaxation in age at the initial qualifying stage would not fall foul of these circulars. Rule 4 of the SEF and RFO competitive examination rules of 2008, read with this schedule, clearly stipulates that the preliminary test is merely a declared to candidate qualified for appearing in the written examination. The examination and the interview performance along with the alone would be criteria for his and her selection for the appointment to the post. Therefore, the relaxation at the stage of preliminary stage would not amount to grant the benefit of reservation of selection. It is argued that Section 8 of UP Public Services Reservation for Scheduled Caste and Scheduled Tribes Act 1994 is identically worked in circular dated 29 January 2000 and 23rd July 2004 in the state of Gujarat. Therefore, the ratio in Jitendra Kumar Singh shall be squarely applicable to the facts of this peasant's case too. He has relied on the judgment of this court in Ajit Kumar P. and Remin Kea and Vikas Sankala and Vikas Kumar Agarwal in support of his submission. Next page, paragraph 11. On the other hand, the Pritesh Kapoor, the learned senior counsel, submit that a candidate who have availed an age relaxation in selection process as a result of belonging to a reserved category cannot thereafter seek to be accommodated in general category seat. In connection, he has drawn our attention to the circular dated 29 January 2000 and 23rd July 2004. It is further submitted that the judgment of the court in Jitendra Kumar Singh has no application to the fact of this case, and the decision was rendered in the context of policy adopted by the state of UP. In support of his submission, he has relied on the judgment of the court in Deepa EV and Union of India and Gaurav Pradhan and versus state of Rajasthan. It is argued that the relaxation in age granted in initial stage in the state in the instant case is necessarily an incident of reservation under Article 16(4) of the Constitution of India. We have clearly carefully considered the submissions of the learned senior counsel made at the bar and perused the material placed on record. For deciding the issue involved in this appeal, certain important aspects are required to be considered. The said state government, in exercise of its power conferred under Article 309 of the Constitution of India, made rules of 1967 by notification dated such and such as per the sub-rule 2 of Rule 8 of the appointing authority has been given power to relax age limit in favor of the candidates belonging to SC and ST, and SEBC, and in favor of the women's candidate to the extent indicated therein. The Ministry of Personnel, Public Grievances and Pensions via Office Memorandum dated 22nd May 1989 formulated a policy in the tune of Article 16(4) of the Constitution of India, which enables the state government to provide the reservation for the category of person belonging to backward classes. Thereafter, the Ministry of Personnel, Public Grievances and Pension via Office Memorandum dated such and such clarified the earlier Office Memorandum dated 22nd May 1989. In the meantime, the state government in the its General Administration Department via Government Resolution dated 11 December 1986 formulated a policy to the effect that the member belonging to SC and ST categories who are selected for appointment by the direct selection to any service or post included in the state service and in the subordinate services on the basis of the merits, their merits shall be considered for appointment on unreserved post, which are filled in on merit along with other general category members. As per the said government resolution dated 11 December 1986, such appointments on merit of the members belonging to such castes and tribes shall in no way affect the claims of the members of such castes and tribes for appointment in the services or on the post reserved for them under the government order issued from time to time. The state government via such circulars dated such and such clarified that a reserved category candidates, if has not availed the relaxation, age limit, experience, qualification, my lord, number of chances to appear in the examination, the said candidate will be adjusted in the open category. and in case of candidates has availed any of the aforesaid relaxation, he or she will have to be adjusted against the reserve seat. These circulars read as under. After careful and mature consideration in this
So
regard,
that's all right. Then what happened?
then kindly look to my lord, paragraph 15. The state government came out with the further clarification dated 23rd July 2004, and in its circulars, it was clarified as under. After careful consideration of the government in this regard, it is clarified that the candidates belonging to scheduled caste, scheduled tribes, socially and educationally backward classes who got selected on merit through competitive examination without availing the relaxation in prescribed standard for eligibility shall not be adjusted against the reserve post. But candidate belonging to the scheduled caste, scheduled tribes, socially and educationally backward classes who got selected by availing relaxation in qualifying marks in competitive written examination and personal interview shall be counted against the reserve post. However, reserve class candidates who have been granted exemption from paying examination fees shall not be barred from competing for an unreserved vacant post. Thus, the appointment in the category of SC, ST, and other backward classes to the post of class 1 and class 3.
One second. So, if a scheduled caste, if a reserved candidate wishes not to avail of the concession from the very beginning and participates from the very beginning under the unreserved category, then he or she shall proceed on unreserved category.
General category.
Yes,
General category. There is no bar.
Right. Because he or she has chosen not to avail of the reserved facility.
Just to compete with the general category.
She has chosen.
Yes. According to their merits.
That's right.
According to their merits.
She will not be stamped, he or she will not be stamped as a reserved category at all.
No.
But the moment one candidate gets an advantage by choosing to become a reserved candidate, then it is, of course, an incidental to the reservation. Incidental to the reservation.
And relaxation will be counted. Relaxation of reservation will be counted.
Naturally. So he cannot be allowed to shift to general category. That is your contention. Then what is the judgment? Show me.
Then paragraph 16, my lord. Does the appointment
comment to there is a original side matters, I believe.
But can it be taken up tomorrow?
করো
না আমাকে হাতে তবে ঝামেলায় পড়বে তারপরে তুমি তো অবজেকশন দেবে ঠিক হবে প্রাইমারি কোর্টে কেসে মামলা
ম্যাটার আছে original side দুটো আছে তো হ্যাঁ মুখটা বাড়ান বলুন আমার
কালকে করো তো প্রাইমারি কোর্টের কেসেই মামলা কি
I will take up appellate side if the 2 p.m. matter collapses. I will sit and I will call a list. And if you wish to do, you're welcome. Both of you are welcome.
But can it be taken up tomorrow?
If it collapses, if it collapses, the original side list collapses. If that 2 p.m. matter collapses, I will take up appellate side list.
But kindly take up the matter tomorrow, my lord, this matter. Because I have other matter in court number division bench.
Tomorrow I have some difficulty.
You agree whatever you want to.
দাদা আমি তো বলবো এখনো তুমি দেখো না
তুই বল আমি ফার্স্ট হাফে আসবো না সেকেন্ড হাফে দুটো
তাহলে ফ্রাইডেতে করো ফ্রাইডেতে বলি ফ্রাইডে করো
If it collapses, if the 2 p.m. matter collapses, I will take it up today. And if that does not collapse, that will go on. And even if it collapses, you don't do this matter, I will take
to continue with this. If anything matter, let them take it adjournment because otherwise everybody will lose the thread. Let us continue.
If it collapses, you continue. If you don't continue, then I will have to call the list, appellate side list.
Before my lord rises.
Yes.
Take some cooperative matters on witness.
You got the number. এটা ওয়েডনেসডে তে কোঅপারেটিভ মোশনে দিয়ে দিন।
My lord,
হ্যাঁ, ওয়েডনেসডে, নেক্সট ওয়েডনেসডে তারিখ বলুন।
10th.
10th তো প্রথমে আমরা কোঅপারেটিভই নেব, তাই তো? তাহলে কোঅপারেটিভ মোশনে দিয়ে দিন এটা 10th।
Lordship, item number 20, Lordship, I appeared online on behalf of respondent number 3. I have given chat box my name, Lordship. My name be kindly be recorded, Lordship.
May I have?
Item number 20, Lordship.
May I have your lordship?
আপনি কিছু বলবেন? জিজ্ঞেস করুন। মহিলা দাঁড়িয়ে আছে, কিছু বলবেন?
To be mentioned.
হ্যাঁ, ওয়ান। কি মামলা? কি হয়েছে আপনার? কি মামলা?
মাই লর্ড, আমি খুব অসুস্থ, আমাকে যদি একটু টাইম দেন, অ্যাটলিস্ট 1 উইক। আমি
কি
অসুস্থ।
কোন মামলায়?
এটা হচ্ছে ফিফথ রেকমেশন, যেটা
মাইকটা নিন ভালো করে।
I am a dismissed employee of Calcutta Corporation Cooperative Credit Society Limited. The matter is fifth reclamation, which was adopted by
কত নম্বর মামলা?
to be mentioned.
Be mentioned.
হ্যাঁ,
কেয়া কর।
কেয়া কর তো অ্যাসাইন ম্যাটার মাই লর্ড। তো আমি খুব অসুস্থ, আমাকে যদি একটু টাইম দাও, অ্যাটলিস্ট 1 উইক। আমি খুব অসুস্থ, হসপিটালে এসেছিলাম।
হ্যাঁ।
একটু যদি টাইম, আমি ইন পার্সন করছি, একটু যদি টাইম দেওয়া হয় আমাকে এবং ফিক্স করে দেওয়া হয়।
আপনার অপর পক্ষে কারা আছেন?
I'm
You
for
are
the
there.
registrar.
Huh?
I'm for the registrar, and the society was also represented.
Of the cooperative?
The cooperative society.
Calcutta Corporation Cooperative Credit Society Limited.
আচ্ছা, so you are for the
I'm for the registrar.
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 Who is for the cooperative society?
Answering, Mr. Sijan Naik is for the cooperative society.
For the cooperative society.
আর মিস্টার স্টেটের একজন আছেন, ওনার নাম কি? অমর্ত্য পাল, ওনার জুনিয়র মিস্টার
আচ্ছা, ঠিক
স্টেটের।
আছে। তো আপনি এক কাজ করুন,
হুম।
আপনি, উনি তো জেনেই গেলেন,
হুম।
মিস্টার সৃজন নায়ক কেউ উনি বলে দেবেন।
না, উনি আছেন, সিজন নায়ক আছেন বাইরে।
কোথায়?
ওনাকে দেখলাম, ওনার জুনিয়র
He
আছে।
was outside. I think he had to go to court number 9. He was
All right, you inform him.
I will.
and inform স্টেট।
আপনি স্টেটের অ্যাডভোকেট সাহেব তো
শান্তনু মিত্র, মনে পড়েছে,
প্রশান্ত মিত্র,
শান্তনু
কুমার মিত্র।
শান্তনু কুমার মিত্র। আপনি শান্তনু কুমার মিত্রকে একটা নোটিশ দিন। কবে রাখবো বলুন আপনি?
মাই লর্ড, ওনার ক্লার্ককে যদি আমি বলে দিই, ওনার ক্লার্ক খুব ভালো।
বললে তো দেখুন, যদি এসে বলে আমি নোটিশ পাইনি, আমি তো তখন জোর করতে পারবো না মামলাটা করাবার জন্য। আপনি একটা ওনার ক্লার্ককে
আমি একটা নোটিশ করে দিচ্ছি,
দিয়ে তাকে দিয়ে সই করিয়ে নিন। ঠিক আছে, সই করিয়ে নিন যে মামলাটা কবে আসবে। এখানে আমার পেনটা কোথায় গেল? লাল নীল পেনটা যেটা দেখছিলাম। পেজ, আপনি এক কাজ করুন, কবে রাখবো? আজকে কি বার? You tell me when. Shall I keep it at 2 p.m.?
Anytime. Any day, anytime.
Also,
As per her convenience.
At least 7 days, my lord. Next Wednesday or Friday. বুধবার বা শুক্রবার।
This writ petition appears under the heading to be mentioned. Full stop. M.S. Kea Kaur.
Miss Kea Kaur.
M.S. Kea Kaur, comma, the petitioner appears in person. Full stop. He prays for an early date of hearing. Full stop. Paragraph. Mr.
Ankit
Surekha, learned advocate, appears for respondent numbers
3, 2, 6 and 9.
3, 2, 6 and 9. Full stop. Paragraph. The petitioner submits that Mr. Shantanu Mitro, learned state counsel, appears in the matter, representing the state respondents, and Mr. Srijan Naik, learned advocate, appears for respondent numbers
for the cooperative society. The cooperative society
of the relevant cooperative society. Full stop. Paragraph. The petitioner, the writ petition shall appear under the heading. Ki affidavit complete? Huh? Hearing assigned. It's assigned. Ki ache?
Assigned.
Hearing bracket assigned on July 18, 18ই জুলাই,
আসছেন তাই
18ই জুলাই, July 18, 2024. Under the
2
বলে
PM
দিয়েছি তো?
my lord 2 PM হলে ভালো হয় দুটোই
Marked at 2 PM. Paragraph. The petitioner shall serve notice upon Mr. Naik and Mr. Mitro, learned advocates appearing for the respondents who are not present today.
in the meantime my lord
Mr. Naik এসে গেছে।
yes, my lord
আচ্ছা, Mr. Srijan Naik ও present লিখে দিন। Appears for
My lord, respondent number 7.
না না শুরুটা বলুন।
18 জুলাই
Appears in person, তারপর ও prayer করলো for hearing, তারপরে কি লিখলাম? Mr. Ankit Sureka
18 July 2 PM
আচ্ছা, paragraph. Mr. Srijan Naik, learned advocate, appears for the relevant cooperative society,
Respondent number 7. Respondent number 7.
comma, the respondent number 7, full stop, paragraph. None appears for the state today. Oh, Mr.
Amortopal, led by Mr. Shantanu Kumar Mitra.
Mr.
Amortopal.
Amortopal, learned advocate, led by Mr. Shantanu Kumar Mitro, learned state council, appears for respondent numbers, state respondents. হয়ে গেল? Paragraph. The writ petition shall appear under the heading hearing bracket assigned, marked at 2 PM on 18ই July, July 18, 2024 at 2 o'clock. 2 PM.
my lord in the meantime my original ফাইলটা একটু দেখতে চাইছি ওখানে একটু যদি লিখ দেন
Original বুঝতে পারছি, original file
অরিজিনাল ফাইল ওর মধ্যে কিছু পেপারস আছে যেগুলো আমার একটু দরকার আছে দেখার একটু যদি আমাকে অ্যালাউ করেন লিভ দিন
নিশ্চয়ই দেখতে পারবেন। 4:30 3:30 পর আসুন, আমার কোর্ট অফিসারের প্রেজেন্সে আপনি দেখবেন।
একদম
শুনুন, হ্যাঁ, আর কিছু দরকার নেই। ওনাকে দেখাবেন আর আপনি পাশে থাকবেন, আপনি ওনাকে হেল্প করে দেবেন। ফাইলটা এখান থেকে যেন না বেরোয়, ফাইল এখানে বসে উনি দেখবেন, সাইডে একটা চেয়ার ওই সামনে চেয়ার দিয়ে দেবেন, দেখবেন, আপনি ওনার সঙ্গে থাকবেন যেন ফাইল না বেরোয়। উনি যা দেখার দেখে নেবেন, কিছু ডকুমেন্ট যেন না বেরোয়, ওখান থেকে দেখে উনি চলে যাবেন।
নেক্সট মানডে মাই লর্ড
আপনি কিন্তু থাকবেন
মানডে মাই লর্ড আফটার 4 PM
আজকে 3:30 পর।
মাই লর্ড আমি আলসার পেশেন্ট খুব পেন হচ্ছে
তাহলে তো
একটু প্লিজ কনসিডার মি মাই লর্ড আমি অ্যাজ পার ইওর ইনস্ট্রাকশন উনি থাকবেন, আমি জাস্ট একটু দেখে নেব।
আপনি দরকার আপনি এখনই ওখানে বসুন, এখনই দেখে নিন। আপনি কোণে বসুন, একটা চেয়ার গিয়ে জাস্ট in the second row, Mr. Chaudhary, Jishnu Chaudhary, please spare your chair.
Yes, of course.
আপনি ওই সেকেন্ড রোতে বসুন, বসে ফাইলটা দেখে নিন, ফাইলটা ওনাকে দিন, ঠিক আছে?
ওনাকে কিছু কিছু দেখানোর বিষয় ছিল যেগুলো
ওনাকে দেখিয়ে আপনার কোনো দরকার নেই, আপনার নিজের যদি কিছু দেখার থাকে আপনি ওখানে বসে দেখে নিন, ঠিক আছে? আর অমিবাবু আপনি একটু ওনার সঙ্গে থাকুন, ওনাকে হেল্প করার দরকার হলে থাকুন। হ্যাঁ, কোনো কাগজ যেন না বেরোয়, কোনো কাগজ যেন চলে না যায়।
Only, my lord, I never seem to run out of excuses to embarrass myself. Lord, there's a supplementary list published by, my lord, the Division Bench of Justice I.P. Mukherjee today, fixing a matter at 3. My lord, if I may continue till 3:10, my lord.
Then better do on the next day, because I am in the midst of a continuing hearing on the appellate side.
I leave it entirely to Lordship. My lord, I was not there on a previous occasion, so my lord, I am extremely embarrassed. So, my lord,
No, my lord.
No, but I make it clear, sir, in any event, Mr. Saha, I make it clear that if you are somehow stuck on the next day, your juniors shall proceed. Your learned juniors shall proceed.
I have only, I mean, I totally want to make it easier, my lord.
I don't, my lord, have any objection. My only request is, if your lordship, my lord, permits, my lord, some short dates to be given, and my lord, that's
Well,
the only
I leave it. Well,
I'll tell you, lordship, the prejudice.
I will not
There
ask
are
for
3
time.
suits.
He has seen my lip movement.
Yes.
Ashok.
Short date. Short date.
My lord, one respectful submission, my lord, in this matter. My lord, the official liquidator is saying, my lord, this company has already gone into liquidation. That's why, my lord, he has instructed me, my lord, they have instructed, the officer of the official liquidator has instructed me to appear in the matter, my lord. But they are saying this company has not gone into the liquidation, my lord. I do not.
They are saying will not do, your record will prevail.
Yes, my record, my lord, just now, my lord, I have been given, my lord, detailed history of this case, my lord. And my lord, I've been asked, my lord, to appear in the matter.
Scene number 10 years.
Scene number.
No. Wait. Yes. Now, if the company had gone into liquidation in 10F appeal,
The control of the company, my lord, becomes irrelevant. I don't know.
very well.
There is a confusion with regard to the my lord, Hanuman Cotton Mills, my lord, or limited, or Hanuman Cotton Mills, my lord, whatever it is.
Mr. Saha,
May I solve the problem?
will he hear me?
No.
Yes, never.
No, no.
No.
Only after he has finished, my lord, everything, exhausted himself, then maybe.
No, my lord, yes.
This is not the
Sorry,
first,
my lord, sorry.
not the first time, my lord, that my learned friend has made this
Let me clear my mind. Mr. Shiv Chandra Prasad, Planet Council appearing for the official liquidator, you must come up with an affidavit to be affirmed by your official liquidator, disclosing the relevant materials in support of your contention.
Yes.
Because in any event, I am adjourning the matter for, let's say, 7-10 days. You must do that. Upon copies to both the, yes, Mr. Shah's client and Mr. Chaudhary's client. They are the basic rivals in the matter, under whatever nomenclature. So do that.
Yes.
Because if ultimately company has gone into liquidation, then that CLB order may not also be enforced.
It will be void because it says wound up by order dated 3rd August 88.
Oh my God.
88 made in CP number 100
Very well.
of 1986.
More the merrier.
Number 10 years been.
More the merrier. More the merrier.
দেখা যাক না কি হয় একটা কাহানি দেখো
চলো লেখো
yes my lord
আসুন
দেখাতে পারবো তুমি একদম
Mr.
হিরো হয়ে যাবে
Jishnu Shahal and his senior counsel appearing for the appellant in APO 211 of 2013. আচ্ছা ঠিক আছে এইভাবে লিখুন appears for London Senior Counsel appears for appellant in APO 211
of 2013.
paragraph. Mr. Jishnu Chaudhary, please listen. Mr. Jishnu Chaudhary, Learned Counsel, appears for the appellant in APO 210 of 2013. Full stop. Both the Learned Counsel opposing each other in both the appeals. আলাদা করে লেখার দরকার নেই. Paragraph. Today, when the matter has been taken up for consideration, further consideration, Mr. Shiv Chandra Prasad, ভুল হলে কিন্তু আমার জীবন হেল করে দেবে, ভুল না থাকে. Mr. Shiv Chandra Prasad, Learned Counsel, appears for the official liquidator, Kolkata. দেখি বাবা, what is that? Instruction.
instruction my lord yes he is confusing my lord today.
He places a written instruction.
That's
now
a brief detail
document, এটা ওর জন্য আমি রাখছি, ঠিক দেখায় না. On the basis of the written instruction received by him from his client, he submits that the company in question had already gone into liquidation by an order dated
by an order dated 3rd of August 1988
August 3, 1988.
in CP number 116 of 1986.
In CP number 116 of 1986.
Yes.
Paragraph. If this information is true and correct, then there shall be, then the consequence will be different. From that, what it stands today on the basis whereof the parties are proceeding in these two appeals. Paragraph. In view of the above, comma, the official liquidator, comma, High Court, Calcutta, shall file an affidavit disclosing the relevant records in support of its contention on or before. When?
My lord, your lordship is fixing, my lord, before that, my lord.
You tell me when.
My lord, within 10 days, my lord.
Give me a date.
10 days.
Within, on or before July 15.
Yes.
2024, upon a copy being served on the respective advocate on records of Mr. Jishnu Shah, learned senior counsel, and Mr. Jishnu Chaudhary, learned counsel, appearing for the rival groups. Both the appeals shall appear under the heading for hearing, specially bracketed specially assigned. Agree to it? Agree to Mr. Shah?
Milord, may I request for this date to be abridged, Milord? I'll tell your lordship why. There are 3 reasons. Milord, our whole life is in this factory. Half of it has already. I'm sorry. Half of, Milord, half of it.
Sir, you give me a date by consultation after 15th of July.
After 15th,
17th of July.
15th of July, he is filing affidavit.
Abridgment of this date. Milord, this is for some other company.
Oh,
this is for Hanuman Cotton Mills. He has come before. Milord, Shri Hanuman Cotton Mill is the company. Cost should be imposed.
Let it come on affidavit. Let it come on affidavit.
Now, this is number 1. Number 2, 50% of my Milord factory I had to take off because of a contempt proceeding which Mr. Shah's client has filed.
Sir, if ultimately the record shows this particular company.
We have gone through this before. This is another company. He has come before in this proceeding.
So let the affidavit come, sir.
Yes.
Let the affidavit come, sir. If ultimately this company is not the company which is in liquidation, it will be appeals will be proceeded on that day itself.
Yes. Now the other problem is 50% of my factory is off. I had to take off the shed, Milord, because of their contempt petition. They've had, Milord, they had it, Milord. It's now CAV before Justice Tandon. He's giving me notices to resurrect, Milord, other proceedings where he wants to proceed and do the suit. Milord, Milord, once this proceeding is decided, every other proceeding will be decided.
But I will, sir. But let that affidavit come.
Yes.
Since the contention has been raised.
Very well, Milord.
That's why I am not relying on this written instruction. I asked for an affidavit. Let an affidavit come.
After that day, Milord, kindly permit it
on
to be
that,
every
on
week.
that day itself. Whenever the matter will be fixed on that day itself, you proceed.
Yes, yes.
Because, Milord, our difficulty.
Agree for a date. Agree for a date after 15th any day.
Milord, whatever is convenient to Mr.
Other than any Friday, agree. 17th.
Well, whenever your lordship decides.
18th.
Yes, yes.
July 18, 2024.
Yes, ma'am.
But, order shesh. But Mr. Shah, it is understood. If you are stuck or inconvenient,
No, someone else will start the matter.
Your learned junior will proceed.
Grateful.
Grateful. সামলাও। অ্যাপেলেট সাইড কন্টিনিউইং যেটা চলছিল, এই শুনুন শুনুন শুনুন, বললাম কি বলেছি, such affidavit shall also disclose with the relevant records as to the present status of the subject company in the involved in these two appeals. ঠিক আছে?
একটু এইগুলো দিয়ে আমাকে এই পর্যন্ত ঘুরিয়ে দেবি তো পিটিশনটা নিয়ে নাও।
ওটা কি ইলেকশন যেটা আজকে সকালে এসছে তো, হ্যাঁ ওটা ওইখানে রেখে দিন, ওই সোমবার ইলেকশনের সঙ্গে দেবেন, ওটা মাথায় রাখবেন। ওই ইলেকশন মামলাগুলো সব হবে ওই দিনকে, ওইটা দেবেন, ঠিক আছে? এইটা কেন ফাইল হলো না এখনো? এটা সাদা ফাইল করতে বললাম। হ্যাঁ ঠিক আছে, বেশ করেছেন, তাতে অসুবিধা নেই, কিন্তু ওটা ফাইল হওয়া উচিত ছিল। ঠিক আছে।
Item number 46.
Yes, my lord. My lord, I am placing, my lord, the judgment of 2019 volume 7
Yes, yes.
Supreme Court
do that.
paragraph 16 onwards.
Do that, do that. Yes.
Paragraph 16, page 388 of the judgment. Thus, the appointment in the category of SC, ST and the other backward classes to the post of class 1 to class 3 in the state services are being governed by the aforesaid policies, and the state government and or any authorities effecting direct appointments are required to give effect to the aforesaid policy decision at the time of recruitment process, preparing the
One second. আরে এটা স্লিপ করে পড়ে যাচ্ছে, এটা একটু নামিয়ে রাখুন।
paragraph 16.
আচ্ছা, ওনার আজকে না চোট আছে,
এন্টারলি পড়ছি তো paragraph
বেশি
16
ভারী উঠাতে দেবেন না, আপনারা একটু সময় করে করে দিন। Yes, sir.
33 paragraph. It is evident, paragraph 70, it is evident from the above two circulars that a candidate who has availed of age relaxation in the selection process as a result of belonging to the reserve category cannot thereafter seeks to be accommodated in or migrated to the general category seats. The state of Gujarat framed the rules regarding the recruitment to the post of ACF in Gujarat Forces Services Class 2 Recruitment Rules of 2007. The assistant, Roman 1, the assistant conservator of forests in Gujarat Forest Service Class 2 Recruitment Rules of 2007. 2, assistant conservator of forest in the Gujarat Forest Services Class 2 Recruitment Amendment Rules of 2000.
Skip on, 19.
19. The similarly, state of Gujarat has made the following rules the regulating the recruitment to the post of RFO class 2. That is the range for this is the
Remove,
post. Then
Tommy,
20. The state government by notification framed the examination rules of 2008 in the advertisement published by the GPASC inviting application from the eligible candidates to the post of ACF class 2 to RFO class 2 dated such and such upper age limit relaxation was granted to the candidates belonging to STSC and ACBC candidate. The category. It was also specifically stated in the advertisement that if any candidate belonging to reserve category who applies in the open category, such candidate would not get the benefit of age relaxation. Such age relaxation was granted in pursuance to the Rule 8 of 1967 rules. Then the rules, my lord, has been prescribed. Article 16.4 of the Constitution, an enabling provision empowering the state to make any provision or reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the service under the state. It is purely a matter of discretion of the state government to formulate a policy of concession, exemption, preference or relaxation either conditionally or unconditionally in favor of the backward classes of citizens. The reservation being the enabling provisions, the manner and the extent to which reservation is provided has to be spelled out from the order issued by the government from time to time. In the instance case, the state government has framed the policy for grant of reservation in favor of the SC, ST and OBC by the circular dated 21st January 2000 and 23rd July 2004. The state government has clarified that when a relaxed standard is applied in selecting a candidate of SC, ST, ACBC category in age limit, experience, qualification, permitting number of chances in the written examination, then candidate of such category selected in this said manner shall have to be considered only against his her reserved post. Such a candidate would be deemed to unavailable for consideration against the unreserved post.
So which means this will take care of their argument if they argue. I don't know what could they argue. Now look here, in this case, rule is specified for exemption.
Exemption.
But there is no negative covenant that the candidates shall not be placed in a reserved category. That negative covenant, negative rule is not there.
Yeah.
It provides for a positive rule that these are the candidates who will enjoy the benefit as a reserved candidate for reservation. That does not mean they will not participate in the open category. That they may argue.
Yes, yes.
I do not know what would they argue.
But their argument would be, my lord, in terms of the affidavit in opposition, that the TATE marks and TATE examination is not the, well, the parameter for consideration of the recruitment process. Relaxation given in the TATE is not at all, my lord, the relaxation or reservation benefit.
But unless a gentleman or a lady qualifies the TATE,
yes,
how can he go for the second
that is
lap?
our case.
Second lap?
Yes.
How can he go participate in the second lap?
That is the primary condition.
If somebody then, if that be so, let's see what they argue.
Yes, yes, yes.
Then if somebody does not qualify TATE, he can also appear in the second round.
Yes, yes.
So, next.
Then now let us consider the judgment in Jitendra Kumar Singh. In this case, the court was considering the interpretation of subsection 6, section 3.
And you will also submit, in the light of this submission, you will also show this court what are the guidelines regarding first appearing to TATE, then qualifying the TATE, then shall go for the written examination or second lap.
Then I have to place
Like in
before
the
your
administrative service, prelim and final.
Before your lordship, my lord, I have to place, my lord, the NCT guideline.
Whatever.
Which is specified the steps.
Whatever.
Yes, yes. let us consider the judgment in Jitendra Kumar Singh. In this case, this court was considering the interpretation of subsection 6 of section 3 of the UP Public Services Reservation of Scheduled Castes, Scheduled Tribes and Other Backward Classes Act 1994 and the government instruction of the such and such date. The subsection 6 of the section 3 of the act provided for reservation in favor of the Scheduled Castes, Scheduled Tribes and other backward classes, which is as under.
Correct. Now I read it. Next.
No,
25.
25.
I read rule 3 is 3.6.
The state of UP issued instruction dated 25th March 1994 on the subject of reservation of the Scheduled Castes, Scheduled Tribes and other backward groups in the Uttar Pradesh public services. Last line of this instruction is as under. It shall be material that he has availed the facility of or relaxation, like relaxation in age limit available to the reserve category. Paragraph 26. On consideration of subsection 3 of section 6 of 1994 Act and instruction dated such and such, this court held that the grant of age relaxation to a reserve category candidate does not militate against him as general category candidate if he has obtained more marks than the general category candidates. Here the subject of merit. Then this judgment was based on the statutory interpretation of 1994 Act and instruction dated 25th March 1994, which is entirely different from the statutory scheme under consideration in the instant appeal. Hence, the principle laid down in Jitendra Kumar Singh has no application to the fact of the present case. In Deepa EV case,
so let's not go on all this. Now you come to the conclusion.
Come to paragraph 30.
These are the distinguishing features.
Yes. Paragraph 33 kindly.
If they rely upon any of those judgments, then those distinguishing features will come.
Paragraph 33. Similarly, in Vikas Sankhala, the relaxation of marks of TET was allowed to different categories. After such relaxation, the reserve category candidates were selected as having obtained more marks than the last general category and were included as general category candidates. The general category candidates contended that since relaxation was obtained prior to the circular dated 11th May 2011, reserve category candidates were not eligible to be included as general category candidates. This court, after noticing the circular issued as general category notices issued from time to time, held that the relaxation given in the marks in the TET examination was not a part of the recruitment process. But here in the present case, this was a part of the recruitment process.
No. Show me.
Can you see this court, after noticing the circular
where?
Issued from time to
33. After such relaxation, the reserve category candidate was selected as having obtained
more marks than the last general candidate and were included as general category
candidate
contended that since relaxation was obtained prior to circular dated 11th May 2011, reserve category candidates were not eligible to be included as general category candidates. This court, after noticing the circular issued from time to time, held that relaxation given in the marks in the TET examination was not part of the recruitment process. This judgment also does not assist the appellant in any favor. Here, my lord, in the instant selection process, this was a part of the recruitment process, the TET marks. Then there is no merit in the submissions of the learned counsel for the appellant that the relaxation in age in initial qualifying stage would not fall foul of the circular dated such and such, and the distinction sought to be drawn between the preliminary and final examination is totally misconceived. It is evident from the advertisement that a person who avail the age relaxation at the initial stage will necessarily avail the same relaxation even at the final stage. We are of the view that age relaxation granted the candidate belonging to ST, SC, ACBC candidate in the instance case is an incident of reservation of Article 16(4) of the Constitution of India. And this appeal, there is no merit in this appeal, and this accordingly dismissed.
So what was the division bench? Take me once again, which has been upheld.
Well, kindly see, my lord. division bench judgment. Kindly see, consider first DIPA EV judgments, which is mentioned in the also considered in the instance case. 2000 reported in 2017. কোনটা? কি করে বুঝবো? কি করে বুঝবো? এই তুমি এটা শোনো। আমি এইটা দেখতে। এই যে এটা 2017 June এটাই তো লেটেস্ট নিউজ। না না, এটা কিছু লাইন আমি দেখিয়ে দিচ্ছি, কিছু প্যারাগ্রাফ, জাস্ট একটা প্যারাগ্রাফ।
So division bench, what did it hold? What did it hold? Paragraph 7?
Paragraph 7.
Because division bench was upheld.
Yes, yes, yes.
What the division bench held? The moment SLP was
Paragraph
dismissed.
7. Paragraph 7.
Yes.
Page 385.
Correct.
Being aggrieved by and dissatisfied with the order of the learned single judge, they filed the latest petitions appeal praying for setting aside the order passed by the learned single judge.
Then
Division bench of the High
quoted
Court,
portion.
quoted portion, keeping in view of the decision rendered by the Honorable Supreme Court as well as the court discussed herein above, and in view of the discussion made by us, the aforesaid paragraphs, we are of the opinion that the state of Gujarat has framed the reservation policy by government resolution dated 11th February 1986 and the circular dated 20 such and such, as well as in view of the statutory provisions, recruitment rules of 1967, rules of 2007, 2008 and 2009, we hold that all those candidates belonging to a reserved category, if avail the benefit of age relaxation, the same is to be considered as relaxation in the standard, and therefore such candidates who got the benefit of age relaxation are not entitled to be considered in the general category, and their cases are required to be considered for reserved category cases only.
So you are supporting this.
Yes.
You are taking shelter of this proposition, and the said proposition was upheld by the Honorable Supreme Court.
And now, my lord, kindly look to my lord, the judgment, my lord.
Next.
TIPA EV, my lord, versus my lord, Union of India and others. এটা 17
বিরোধ তো তারপরে
reported in my lord to 2017 volume 12 Supreme Court cases, page 680.
2017
volume 12 Supreme Court cases, page 680.
Paragraph
4, 7 and 11.
Petitioner বলে আজকে ডেট দিয়ে দিন। Paragraph
4, 7 and 11.
Has this judgment been considered afterwards by the Supreme Court in any other subsequent judgment?
No, that I know. Because it is considered in the earlier judgment that I
That's right, that I have seen. But after that, so according to you, this 2019-7 Nirvankur Dilip Bhai is the last one.
Admitted.
All right.
Kindly see my lord, paragraph 4 once I am reading. The appellant who has applied under OBC category by availing age relaxation and also attending the interview under OBC B category cannot be claimed right to be appointed under the general category. And paragraph 7 and 11. একটু ধারা তোরা ভীষণ ডিস্টার্ব করিস কিন্তু আর এটাকে নিয়ে এসেছিস কেন? এটা
Right.
And kindly see the page 684, top.
Read it.
If any person belong to reserved categories is selected on the basis of merit in open competition along with the general category candidates, then he will not be adjusted towards reserved category. That is, he shall be deemed to have been adjusted against the unreserved vacancy. It shall be immaterial that he has availed any facilities and relations. That, your lordships, before my argument, my lord, your lordships. From the above, it becomes quite apparent that the relaxation in age limit is merely to enable the reserved category candidates to compete with the general category candidates. All other things being equal, the state has not treated the relaxation in age at fees as relaxation in the standard of for selection based on the merit of the candidates in the selection test, main written test followed by the interview. Therefore, such relaxation cannot be deprived a reserved category candidates of the right considered as a general category candidate on the basis of the merit of the competitive examination. The judgment, my lord, based on merit. If the merit of the reserved category candidates is higher than the unreserved category candidates,
Last candidate in the
yes,
unreserved
they
category.
can compete with the general category candidate. There is no bar. And thereafter, my lord,
Even if they get the relaxation.
yes, yes, yes.
Even if they get relaxation.
No.
If a reserved category candidate gets a higher marks,
last empaneled
last
candidate
empaneled in the general category, then he can join the general category
according to his merit.
According to his merit.
There is no question of availing any reservation, relaxation, nothing. According to merit.
No. Yes, because he is not required to get that benefit of 5%.
Yes.
Benefit of 5%.
Yes, yes, yes.
Because on merit he is higher than that.
Higher than the last empaneled candidate.
Let's say if a reserved candidate scores the highest mark in throughout the selection process. Highest marks in throughout the selection process. Then he comes first.
First.
Even in the reserved categories. Unreserved.
Unreserved category. First.
Then
placing a judgment, my lord, subsequently reportable.
এইগুলো বলুন সব ওই সাদা ইয়েতে দিয়ে দিতে আমার ফাইলে
রিপোর্টেবল
এইভাবে করবেন
এটা হচ্ছে গভর্নমেন্ট অফ এনসিটি দিল্লি ভার্সেস প্রদীপ কুমার
পিটিশনার ব্র্যাকেটে ডেট তারপর সিরিয়াল নাম্বার
তুমি না ওকে
না না একটা দিন না যেটা উনি দিলেন ইয়েস
হিয়ার মাই লর্ড October 2019 একদম কাঁচা ইয়ে তাই তো
Yes.
Paragraph, kindly look to me, paragraph 24, page 17. Man, I am not reading the paragraph 24. বেশি টাইম নেবেন না এই কথাগুলো বলো না রিপোর্টেবল May I read, my lord? It is important to keep in mind that the respondents are competing for general category vacancies. All others in these groups have obtained their seated eligibility qualification, securing the normal PAX marks without availing any relaxation of PAX norms. On the other hand, the respondent, despite of their lesser marks in CTET examination, that is central trait, the other candidate got lesser marks in the central trait examination, could qualify only because they avail the relaxation benefit as OBC category examinees. Their eligibility qualification is secured under the relaxed norms meant for OBC category. Therefore, we do not think it is proper to consider them to be eligible for general category vacancies, and the contention to the contrary is unacceptable. That is my contention.
So once the benefit has been obtained, you go and remain in that class.
Your
class.
category, your caste category, not in the your category list. That's all.
Now, according to you, according to you, the entire selection process is over.
Yes.
The panel stood expired as on date. Today.
But before expiry, my lord, I filed the writ petition.
Now, what do you say if ultimately the court holds in your favor? Then what would happen?
A panel should be set aside. Because the preparation of panel, if it is prepared in violation of the policy of reservation, then my lord, it should be cancelled. Because the settled principle of law is this.
This is not the time.
The others may be released, Lordship. I believe nothing will, they will continue.
Sir,
3:30 today, Lordship.
Yes, my life.
You will continue.
I'm grateful, Lordship.
বলে দিন, announce করে দিন, other matters stands released.
Grateful, Lordship.
Announce করে দিন. Announce করে দিতে হয় মাইকে. All other matters except this continuing matters stand released for the day.
All other matters excepting item 46 are released for
the day.
For day.
Yes.
There is a settled principle where, my lord, a candidate cannot avail benefit twice.
I'm not on that. That is one aspect.
Yes.
Second aspect is panel is settled for, let's say, 4 or 5 years. Then what is the law on that?
If, my lord, the panel, my lord, what has happened, my lord? The date of filing the petition,
I have understood your submission that if a panel is in violation of the policy, panel cannot exist.
Panel goes.
That's right. Recasting of panel.
Recasting of panel. In terms of the merit, in terms of the.
But is there any law? Can you show that when in such a case, the panel is settled for last 5 years?
Then what will
employment is settled?
Then what will be the consequences?
Yes. Even if.
Yes.
Or you will be, your remedy remains in damages.
Well, according to the recruitment rules, after exhausting the main panel, in terms of Rule 12 of the recruitment rules of 2016, they have to publish an additional panel of 5% of the total vacancy. The number would be total number of vacancy was there 16,500 and 5%.
800, let's say.
800. That list has not yet been published. If the panel expired, according to them, in the other matter, my lord, they used an affidavit they filed a report by way of an affidavit stating that the panel of the 2020 recruitment process is expired in the month of March or May of 2023. Then, my lord, my writ petition, I came to know the marks of the appointed candidate in the.
Admitted,
Yes,
your
yes, yes.
petition is prior.
Yes, yes.
Admitted. But the point I am asking the query, it's a query of the court.
That I understand that.
What do you
four and
say
five
to that?
was that.
What do you say to that?
Well, even if, my lord, the delay is in.
I'm not on delay.
No, no,
not
no.
on
Even
delay.
if, my lord, but when, my lord, your lordship was find as that there is a wrong in preparation of the panel, your lordship can interfere with the preparation, my lord. There is no.
Bring such decision also.
Yes, yes, yes.
Ultimately, the decision will be mine.
Yes, yes.
Fair
No,
enough.
no, no. I have a.
Fair enough.
Well, I can place before your lordship 2 Supreme Court judgment on the next date. Regarding, my lord, one of the selection, my lord, initiated by the Delhi Public Service Commission. Entire selection process is cancelled after 6, 5, 7 years.
After the panel was allowed to be settled.
Yes.
Bring those.
Yes, yes.
Bring those.
Yes, ma'am.
Because at the end of the day, I'm also a court of equity.
Absolutely, ma'am.
I'm also a court of
Absolutely, absolutely.
16,000 employment.
Yes, yes, yes.
You have completed.
Yes.
Yes, Mr. Sanyal. এই পাখাটাকে একটু কমাতে দাও। দেখি কাগজটা তুলে দিন। আস্তে আস্তে করুন, কোনো চাপ নেই। Yes, Mr. Shubhi Sania. You are for?
But I'm for the respondent number. 3, 4, and 5.
Who are they, sir?
West Bengal Board of Primary Education, the president and the secretary. They are the recruiting and recommending authority, not the appointing.
Respondent number 3.
4 and 5.
Who shall be your next speak learned advocate to submit for any other respondents?
I do not find one.
There are many risks because, my lord, I made party, my lord, all the DPSCs. Because, my lord,
Not only that. The
there is a
successful
direction.
Candidates.
They are not parties.
They are not, because, my lord, we don't know the details of.
That's right.
My lord, in the writ petition, my lord.
Order 1, Rule 8.
Well, Rule 8.
Order 1, Rule 8.
Publication. But what has happened, my lord? In the writ petition, I praying leave to supply the number, details of these candidates, my lord, from the, my lord, West Bengal Board of Print. That leave.
No, but still.
Order 1, Rule 8. Yes, yes, yes. Publication.
Order 1, Rule 8 is there.
Yes.
All right, let me hear first.
My lord, I first tell you, Lordship, this petition is a jumbled up petition.
You come to the core.
This is the code. All the points I will report 3, 4 points. My lord, the paragraph 6.
Sir,
253. The petitioners participated in the teacher eligibility test 2014 in terms of the notification dated 26 June 2015. The petitioners qualified in the teacher eligibility test 2014, and the petitioners are all trained candidates having B.Ed and DLED qualification respectively. Now, my lord, the petitioners are all TET qualified, but mere TET pass do not make them qualified unless they have the other qualifications. My lord, I do not know who are having DLED and who are having B.Ed. B.Ed are unqualified. So at least at the instance of the B.Ed candidates, read not maintainable.
Big microphone. Mic.
B.Ed are not qualified. So at least at the instance of the B.Ed candidates, REIT is not maintainable. REIT petition do not specify who are B.Ed or who are DLED. This has been held by the Supreme Court.
Yes, the rule of the game. If the rule of the game specifies B.Ed only, then B.Ed.
Rule specified, my lord, when the selection process, my lord, held in 2020, at that point of time, both B.Ed and DLED eligible as per NCT notification. But, my lord, the REIT petition was pending throughout India. In all, it's a pan-India aspect, my lord, because the NCT made the B.Ed qualified candidate eligible only in 2018. Well, the first REIT petition was moved in our High Court, but I could not get it heard. I was moving for them, against them, but I could not get it heard. Well, in the meantime, Rajasthan High Court matter was heard, and the Rajasthan High Court was the notification of NCT, my lord, making the B.Ed qualified candidate eligible. Now, that was taken before the Supreme Court. Now then, Supreme Court issued notice to all the parties throughout the country to come and make your submissions. Our REIT petition was also taken over there by one application. And ultimately, Supreme Court held the NCT notification unconstitutional and therefore quashed. Now, as a result, the persons who have been appointed as B.Ed, their appointment goes. So they moved an clarification application. Then Supreme Court said in the clarification application that those who have already appointed, they are saved. Those who are already appointed, those are saved, but the rest are not. So, they are not selected or appointed. So they cannot move it.
So have you disclosed this in your affidavit in opposition?
This is the latest judgment.
No, not only judgment. You have taken this point.
Yes, B.Ed qualified, I have taken point.
Regarding B.Ed, they have taken point. In reply, I have stated that in the recruitment process of 2020, they appointed more than 7,500 B.Ed candidates.
But I tell you, Lordship,
and the order passed by.
What he has said, even if they were appointed, sir, here, the issue is different. Your short point, who have availed of the reservation advantage, they cannot be included in the general category forever.
Yes.
Their door is shut. That's your short point. Nothing more than that. Mr. Sanyal is saying, yes, B.Ed were appointed. I don't disagree to that. Subsequently, Supreme Court said B.Ed were appointed at a juncture when that notification was not quashed. But subsequently, Supreme Court quashed, disallowing B.Ed. With a caveat, those who have been appointed, they will remain.
The order passed in Devesh Sharma matter, the B.Ed matters. Dated, my lord, 11th August 2023. The order, my lord, effect of the order prospective, not the retrospective.
That's right.
From the date of the order.
But no, if the Supreme Court directed, Honorable Supreme Court directed those who have appointed already, their appointment is saved. Still, will you argue that it is prospective and retrospective? Then he is saying the same thing.
Yes.
You are saying the same thing. It is the Supreme Court who had directed that those who have appointed already, they are saved. The rest are not saved.
The order passed in Devesh Sharma matter, the B.Ed matters. Dated, my lord, 11th August 2023. The order, my lord, effect of the order prospective, not the retrospective. From the date of the order. From no, if the Supreme Court directed, Honorable Supreme Court directed those who have appointed already, their appointment is saved. The rest are not saved.
Then how do you argue this? Even if it is under 142, even if. That cannot be your, that is no plea to be available to you.
The judgment of the Honorable Supreme Court. But this is the main judgment, this is the clarification. Both.
No, Mr. Sanyal, today we have hardly any time. First, today you proceed with your points of argument.
This is fast.
এটা নিয়ে নিন, নিয়ে লিখুন respondent numbers 3 to 5. Respond R 3 to 5 ডেটটা দিয়ে দিন 1 নম্বর। জাজমেন্ট দুটোতেই লিখুন 1 নম্বর। R 3 to 5. Yes.
Now
This is your first point.
Now the second one, your lordship. This is a recruitment process of 2010. 2020. Sorry, sir. Panel was published on 2021. It got lapsed 2022. In the same recruitment process, matter was taken up before the Honorable Supreme Court by my learned friend. Supreme Court says that this matter has, the panel has lapsed. Nothing can be done on it.
And it has lost its life.
Pendency immaterial.
So, perhaps I have asked him the right question.
Yes, your lordship, the first one.
The right question I have asked.
My lord, your lordships will find just paragraph Roman 2 and 3 of paragraph 29.
এটা অন্য দিল। Where the Supreme Court said that? In these two?
2024 SSC online. And then this one. That was to be.
ওটাই 3 করুন। R 3 to 5 আজকের ডেট 3। আর এই দুটো ওখানে আটকে দিন, ওই ফাইলে আটকে দিন। হ্যাঁ, দুটোতেই এক করুন, একই কানেক্টেড ম্যাটার। ওটা 2। Yes, so that is really what is troubling me. Then I will come the next point.
Now, my lord, kindly look on Roman 2, 3 and 4.
Where from?
Page paragraph 29.
Judgment. Wait.
This is, oh, please.
Didi. Roman paragraph
29.
My
lord, let us go through the entire paragraph 29, very short paragraph.
1 second. No, first you show me from this judgment, this arose out of the same recruitment.
That's paragraph 29 itself. First paragraph, Roman 1, 29. In the light of the above discussion, the following conclusions are reached. Number 1, the manner of shortlisting candidates for appointment as suggested by the division bench in the impugned judgments is inconsistent with the procedure laid down under Rule 8 of the Recruitment Rule 2016, and those cannot be sustained. This is governed by Rule 2016. Then, the panel or merit list, as notified on 15th February 2021, stood extinguished after expiry of 1 year, that is to say 15th February 2022, as per Rule 12 of the Recruitment Rules 2016. My learned friend has placed elaborately Rule 2016, but only on other point. Roman 3, no extension by competent authority was granted to the 15th February 2021 panel, and therefore no relief can be granted to the candidates who approached the court in May 2022, or long after the panel stood extinguished. My learned friend's client affirmation of the petition I have checked. This is in the month of January 2023. This petition affirmed on 13th day of January.
13 January
2023. Page running page 291.
All right.
Then 4. No further appointments is permissible.
That is what was really
On the
troubling me.
process initiated on 13th February, December 2022, when a fresh recruitment process has commenced.
Here also fresh recruitment commenced. Next recruitment process. And not only that, this was really troubling me. This was from the beginning, it was troubling me that how far I can lay my hand, even if I find illegality.
No, Malad, after the this Malad, I'm with this one without considering to this. This cannot be done after because the panel has prepared everything. I tell you, losses. Malad Nirod Kumar judgment, Jitendra Singh's judgment. Oh, Nirav Kumar. Anyway.
Yeah, give me that.
That's your losses. My learned friend has cited you before losses.
Which one? 17 or 19?
19. Malad, all the judgments I just, Malad, according to my memory, I keep the glimpses. Because one matter I fought with my learned friend.
No, but one thing, Mr. Sanya, if ultimately this be the ratio, if by this my hands are tied.
Futile exercise. Futile exercise. But even then on that point, I have the submissions. So would your losses go to that or not?
That's precisely.
That's your losses.
That's
point.
precisely. Just take your seat. After this.
Yes.
So you admit that this Supreme Court judgment.
Learned friend, one point. This was my learned friend was the advocate on record.
No,
here,
no.
And Malad, move this matter before the
No, I am appealing for
Forget it. All right. Doesn't matter. Doesn't matter.
before
Doesn't matter. Whatever is written is written. You admit that this SLP arose out of the same recruitment process?
Yes.
Fair enough. Thank you, sir.
Yes.
Now, if that be so, how can I travel beyond 29, paragraph 29? Which the question I asked you before you ended your submission. That's the question.
After expiry of the panel.
No, after the observation of the Supreme Court, mandate of the Supreme Court. How can I lay my hand? Simple question.
But there are minor 2-4 judgment are there.
Not
to show.
required. Not required. I am
Even minor if any illegalities minor cropped up pilot in the recruitment process. And that is.
Sir, I am telling you, the proposition of law, void, ab initio, honest, wholly illegal, total wrongful. But after this mandate, because it is service jurisprudence, the right have settled. Why that question has cropped up in my mind? And I asked the relevant dates, expiry of panel and filing of writ petition. Because the right had settled. The panel was allowed to be settled. The 16,000 candidates, they were selected by the state authority. The presumption is the moment state authority selected them, it's a right selection unless quashed. Right?
Yes.
Now, when a right has settled for last 5 years.
Not 5 years, but 20.
2 years.
2 years.
2 years, let's say. 2
years.
months.
Yes.
And this mandate is there on the face of, it stares at me. Why should I go further? Why should I
Rights
go?
crystallized.
Right has settled.
That crystallized totally.
Crystallized. Now today, if the employer wants to take away the employment of any one of these 16,000, it has to be done with due process of law. Simply cannot be done. Why? Because the right is settled. Now, in such a situation, the equity definitely comes.
And court can interfere.
Court, but the Supreme Court, Honorable Apex Court. Ashu, sorry, this is not the matter. Ashu.
But my lord, the petitioner able to my lord show before your lordship that the mistake in preparation of the panel.
But I cannot go beyond this. I cannot go beyond this. I cannot go beyond this, sir.
But can it be, my lord, adjourned for 1 week, my lord? To, my lord, bring some judgment to show, my lord, that after cessation of the panel.
No. You submit me in law that this is not binding on me. Submit me in law, which is the law point. Submit me here.
At present, my lord.
No, forget about the judgments. You first submit me. This is a decision which is not binding on me. A decision of the Honorable Apex Court sitting in a single bench is not binding on me. Show me.
But the writ petition, my lord, which is, my lord, the formation of the SLP, my lord, is based on, my lord, vacancy, my lord, they are in the recruitment process.
Question. On no uncertain terms. Honorable Supreme Court has held, don't touch it. Don't touch it. And the way, really I was thinking in this way. How can I? After the right is settled?
Settle law.
Ashu. Please assist me in recording the facts, both of you. It is equally, Mr. Counsel, it was equally a very, very pleasantly sessions for me to hear you. On the point of law. Ashu. Through this writ petition, the petition asks, please assist me in recording the facts. Mr. Sannal, through this writ petition, the petitioners were the aspirant for the selection process arising out of the examination
2020 recruitment process.
Out of the 2020 recruitment process
for the post of assistant teacher in primary school.
Assistant teachers at the primary schools in the state. The petitioners participated in the teachers eligibility test,
2014.
Bracketed TET for short TET. The grievance of the petitioners is that the aspirants who participated in the TET under the reserved category and thereby received the reservation benefits under the state policy could not have been included ultimately under the general category list, bracketed unreserved. General category, bracketed unreserved, bracket close, list. Mr. Dibyendu Chatterjee, learned counsel appearing for the petitioner, has very forcefully submitted that the moment the reserved category candidates, after receiving the benefits of the reservation, are allowed to be included in the general category list, the same would amount to encroachment of the space for the general category candidates and would be in violation of Article 14 of the Constitution of
And
India.
also for the candidate who obtained higher marks than the last step panel candidate, he might be reserved category candidate, but he can be placed, my lord, in terms of his merit.
Not required, because your challenge is this.
Yes, absolutely.
Paragraph. In support, learned counsel for the petitioner had relied upon the following judgments of the Honorable Supreme Court. Roman 1, দেখি এবার পুরো বান্ডিল গুলো দেখি। Roman 1, এটা নয়, আমি ফাইল যেটা করতে বলেছিলাম। রোমান ছেড়ে দিন। Roman 1, আমি লিখে দিচ্ছি, আপনি ওই ছেপে নেবেন। জাস্ট আমি একটুখানি বলে যাচ্ছি। ইন দ্য ম্যাটার অফ নীরব কুমার, এটা Roman 1 দিয়ে দিলাম। নীরব কুমার, ঠিক আছে। রিপোর্টেড অ্যাট, আমি যেভাবে লিখি ওই ইটালিক্স করে বোল্ড, 2019 7 SCC 283। Roman 2, লিখুন দীপা ইভি, দেখে নেবেন। রিপোর্টেড অ্যাট 2017 12 SCC 680, Roman 2. Next, Roman 3, in the matter of government of NCT, Delhi and others, rendered in civil appeal number 8259 of 2019, arising out of SLP all cap within bracket C number 11254 of 2019, dated October 24, 2019, Roman 3.
Yes.
ঠিক আছে। হলো? Paragraph. Mr. Subir Sanyal, learned counsel, appearing for respondent number 325, submits that arising out of the same selection process, submits that. Go to which paragraph? 29 না কি বললাম? Which paragraph? Which paragraph? You have shown me.
Paragraph 29. Page I just
না পাচ্ছি না, কোথায় গেল?
last page, last but one page.
দেবেশ শর্মা?
No. Malad Ali Hossain.
তুমি রেফারেন্সটা করে দাও না।
3, judgment number 3. Personal building endorsement 3.
এটা রিপোর্টেড হচ্ছে কোথায় দেখা?
Online.
Give me the dates. Give me the date. Mr. Subir Sanyal, learned counsel such and such, submits that the recruitment process was initiated on
23rd December 2020.
December 23, 2020, full stop. The panel or merit list was notified on
15th
February 15, 2021, which stood extinguished after 1 year.
on
That
15th
is
February
on-
2022.
That is on February 15, 2022, as per the relevant recruitment rules, 2016. The writ petition was filed on January 13, 2023. এই ডেটগুলো সব বোল্ড হবে, এই ডেটের ওপরই কিন্তু মামলা দাঁড়িয়ে আছে। January 13, 2023. Poster. Paragraph. Mr. Sanyal then submits, once the panel stood extinguished and expired, the right of the selected candidates, for about 16,000 in numbers, have already been settled and crystallized. And the same cannot be interfered with at this belated stage. In support, he relied upon full stop. He further submits that arising out of the same recruitment process, self-same recruitment process, the Honorable Supreme Court had dealt the issue in the matter of Ali Hussain, reported at 2024 SCC online SC 1189. এটা কত নম্বর হলো সিরিয়াল? আগেরটা 3 বলেছি, এটা 4। এই নিন দিদি, কি বললাম? reported at পরে in the matter of Ali Hussain, হ্যাঁ দেখে নেবেন এখানে ভার্সেস ওয়েস্ট বেঙ্গল বোর্ড যা আছে পুরো দেখে নেবেন। রিপোর্টেড কি বললাম? along with other connected appeals, না ব্র্যাকেটে করুন, আগে ব্র্যাকেটে করুন, সিভিল অ্যাপিল নাম্বার সি ক্যাপ এ ক্যাপ এন ক্যাপ বোল্ড হবে, সিভিল অ্যাপিল নাম্বার 1873 of 2024, bracket close, along with other civil appeals. Poster. Paragraph. The relevant portion from the judgment in the matter of Ali Hussain Mondol, ওই পুরোটা লিখে দেবে, ব্র্যাকেটে supra is quoted below. Paragraph 29, full quote করুন, লিখে দিচ্ছি quote 1, paragraph 29, ঠিক আছে? Full stop. Paragraph. Full stop. Considering the ratio and the observation made by the laid down by the Honorable Supreme Court in the matter of Ali Hussain Mondol Supra, and considering the observations made by the Honorable Apex Court therein, as quoted above, this court is of the view that there is no further requirement to proceed with this writ petition. Full stop. paragraph. Would you? See page 30 and you are asking me to proceed. See paragraph 30.
Paragraph 30 ki
Earlier
judgment
order
is-
clause. Or earlier order clause.
See paragraph 30.
Yes.
Yes.
আরে এই জাজমেন্ট কি বলিস
In view of the above, কি বললাম পুরো?
অচেনা লাগছে দেখে জানিস তো
Comma দিয়ে this court is of the view that comma there is paragraph. Accordingly, this writ petition WPA 1056 of 2023 stands dismissed, comma,
হিমাকলি
without an order as to cause.
কথা শোনেন
আচ্ছা মাথার উপর একদম লিখবেন this is a hearing matter upon affidavits একদম শুরুতে affidavits yes I have read affidavits hearing matter upon affidavits আসুন
বৃষ্টিতে শান্তিনিকেতন যাবে না? যায় যায় জিজ্ঞেস
এখন আর যায় না।
হ্যাঁ যায় যায়
কোথায় যাবে?
এই জাজমেন্টটা এই অর্ডারটা দাদা এটা তো জাজমেন্ট না অর্ডারটা হয়ে গেলে একটা সার্ভার কপি আমায় দেবেন তো কারণ ওই প্রপোজিশনটার জন্য সুপ্রিম কোর্টের জাজমেন্টটা দরকার আমার অন্য সময়
আমার কাছ থেকে আবার হয়ে পড়ে
obliged
থ্যাংক ইউ